May I please? I beg to mention item number 4 and 5, Lordship.
Yeah.
Yes, Lord. Matter may be kindly adjourned for 2 weeks, Lordship.
No, I'm for appeal, my lord. This matter will be fixed on 6th of May, my lord.
Is regarding that enhanced compensation.
Yes,
Yes,
yes. Second 34, my lord. Landfill was 0, my lord.
Sixth of May.
6th of.
Obliged.
May I please, my lord, with the consent of the other side, I beg to mention item number 9, my lord. Lordship, the conducting council is out of session, my lord. Can it be fixed after Bihu vacation?
Let it be in the second week of May.
Second week of May, anything.
Obliged.
I'm obliged.
May I please, the lordship? Lordship, I pray for listing my writ appeal on Friday, my lord.
Friday.
Friday. Much.
May it please the Lordship, with the consent of the other side, I beg to mention item number 23 of the daily list, Lordship. Lordship, the conducting council, Mr. P. Nayak, has some personal difficulty today. I pray for adjournment.
Much obliged, Lordship.
May I please, Lordship? Lordship, praying for listing of a fresh writ appeal for motion, Lordship. Any day, Lordship, please.
Next week.
Next week.
For listing a PIL, Lordship. On next,
Was the urgency in the PA?
Lordship, actually, Lordship, similar matter is fixed on next Friday, Lordship.
Next Friday.
Yes,
Next Friday is coming Friday or next Friday?
coming Friday, Lordship.
Friday.
Obliged, Lord.
May I please, your Lordship, I beg to mention item number 18, 19, 20, and 21. Lordship, matter may be fixed after Bihu vacation.
19, 21.
Yes,
18
Lordship.
to 21. 18 to 21.
18, 19, 20, 21.
After Bihu vacation.
Much obliged.
Daily list for this item 1.
Yes.
But the Lordship has directed me to obtain the instruction as regarding the progress of the work.
Yes. The second representation regarding
Look, some photographs I have given, my lord, so that lordships can have a clear view.
They said on 15/3, 20% is the progress, Lord.
this alternative road.
Yes, my lord. Top portion of, in the top, some work is there of art cutting and clearing.
Lordship, may kindly take my instruction, Lord. The next page, Lord, they have work program they have given. Give me a copy. Thank you. Photograph काम करते हैं 20% progress W को इसे माफी करते हैं और JBM लिखते हैं माफी काम करते हैं माफी पेज में लिखते हैं पूरा मतलब काम करते हैं हम देखो
This boundary is of that campus,
Yes. High Court campus, my lord.
High Court campus. And what is this about this house?
no photograph I have no idea.
There is a under construction house in the picture at the end of the
The end
road.
of the road.
That is one of the resident, my lord. Perhaps that is
Residential,
one of the.
It has to be, it has to be demolished or the road?
No.
No.
That-
No house has to be demolished. My lord, the top portion, a portion of the land is yet to be cleared by cutting the earth in the top portion. The road, my lord, it turns in front, from the front side of the house, my lord. My lord, I visited once that place, my lord.
So up to the around 50% work has already completed.
They say, my lord, 20%.
20%.
20% as on 15/3, my lord. Now it's going.
So you have proposed to this construct the road by what time?
Well, they have given a work program and they said that May 24, pavement work and road furniture that they will do, my lord, by May 24. In the next page, my lord, they have given a program, my lord.
I think, my lord, some expeditiousness is required because the monsoon is coming, my lord. And it's a hilly terrain.
The work will be completed by the end of the work program. It will be able to complete.
May का 27 तारीख को
Pursuant to the direction given by this court on 8/2/2024. Mr. H.K. Das is standing counsel. The pursuant to the direction given by this court, Mr. Dinath. Dinath, counsel for the government, has submitted the progress report prepared by the Office of the Executive Engineer, PWRD, New Guwahati, Territorial Road Division. Bamuni Moidam, Guwahati, wherein it is mentioned that the construction of the alternative road will be completed by the end of May 2024. Some photographs regarding the ongoing construction of the road has also been placed on the report. Stop the photographs as well as the report of the executive engineer dated 16/3/2024 be taken on record. This matter on 27th of May
My lord.
2024 on that day. So Nath may produce the further, may furnish the further progress report.
My lord,
After, my lord.
deeply obliged.
Item 2,
May it please your lordship, as per order dated 27th, 2024.
Yes.
Yes.
Well, some instruction has been received today, my lord. Regarding the inquiry report of the Sipsagar, my lord.
That inquiry report, we have asked that,
Sipsagar.
what action you have taken
My
against.
lord, that is still awaited, my lord. But with regard to the Sipsagar, my lord, there are two schemes. One is from the Amguri, other is from the Sipsagar. That has been received, my lord. Inquiry has been completed, and it has been found there is serious anomalies, my lord. Conclusion part, my lord.
Page number,
Yes, 1, 2, 3, 3, 4, my lord. Conclusion, my lord.
this Srinagar urban water supply scheme found various irregularities.
Yes, my lord.
And earlier also. in
Yes,
that
yes.
Another also you found some irregularities
Yes,
and then
yes.
we asked you to submit the report
Yes,
regarding. the
yes, my
action-
lord. Yes, my lord.
Action taken. by
That is awaited, my lord. Still, my lord, still that is awaited. Some more time regarding what action is being taken.
What else? Then the inquiry is already there. What remains then?
That's true, my lord, but some more time, my lord.
How much time?
At least 2 weeks, my lord. Let it be after the vacation, my lord. Bihu vacation, my lord.
That report is of May
Uh,
2024.
In fact, my lord, and
February 2024.
yes, yes,
It's almost more than 1 month.
yes, my lord.
Still you have not taken any action, then what remains?
As a case has also has been registered, my lord. Investigation is still on, my lord. One FIR has also been lodged before the Sipsagar police station.
When,
That also investigation has been going on, my lord.
when it was registered?
It was registered, my lord. Along with that representation regarding the anomalies, my lord.
take action as early as possible.
Yes, yes, my lord, yes.
Okay. On 27/2/2024, this court has issued direction to the respondents to apprise this court about the action taken by the state pursuant to the inquiry report filed by the Assistant Commissioner in the Executive Magistrate Sri Sagar. This court has also directed the respondent to apprise about the status of the complaint filed on behalf of the petitioner in relation to Shiv Sagar water supply scheme. Full stop. Learned counsel for the state has submitted that he needs some more time to apprise this court about the action taken by the state government.
I think
That's exactly what I was trying to indicate to your lordship, that if your lordship would kindly indicate in what manner we may be of assistance, we will certainly be.
You have to prepare the
But
report.
the
regarding
report
the
which has been-
discrepancies, if there are any in those shelter homes.
Lordship.
And certainly.
Lordship, there are
certain-
only, as per the report which was submitted to your lordships on the last occasion, I have gone through the report and there are only two shelter homes which seem to be running. One is in the district of Khojai and one is in the district of Nagaon. And Nagaon is also only some about 10, 12 families who have got together and they are residing themselves in a particular area. Whereas in the district of Khojai, where the actual problem had occurred, your lordships will take up the report which was submitted to your lordships by the member secretary Assam's Legal Service Authority. There, your lordships, it says that the persons have already been evicted, and the rest of the people who have now been, they're not trying to rehabilitate in that shelter home. the state government has filed an affidavit that they're doing the extra needful insofar as supplying them with all the necessary
Certainly, they have got
details.
the affidavit, but what they are doing on the ground,
Lordships.
you can very well instruct this DLSS.
Lordship.
District Legal Services Authority, they can go and inspect the site and submit a report before. this
Yes,
board.
My lord, may I submit? My friend must have not gone to the place. I have personally visited that place and I have prepared a report. I'm quite surprised by the observation made by the District Legal Service Authority especially in respect of Hojai, where I have gone and I found that there are 350 children, and this court took cognizance of the matter on a newspaper report because children were falling sick after they were evicted from a reserve forest. So, and there were no potable drinking waters and no sanitation facilities. And now I think during this rainy season, the entire field, they are in a open field, it gets flooded. And
You
the
mean to
court,
say that report which is submitted by the District Legal Services Authority is not correct?
no. I have the pictures. I can even show the pictures of the
Latest pictures?
the last time when I went.
What is the position now?
Well, I can go in the weekend, well, I can go in the weekend.
If you can.
Yes, madam. I can go in the weekend. My friend can also accompany me. We'll both go together.
That was a situation when the PIL was registered, my lord. Ultimately, the steps have been taken and they have been
then
given
do
all
one
the
thing.
amenities. my lord.
Mr. Kovar has already offered you.
Yes.
Your company.
Yes.
Go and inspect the.
Let him, my lord, he can very well go and.
No,
submit-
you
submit
will also
where
accompany me.
No,
sir.
no, my lord, I
Both of you.
Yes.
I have some time constraint, my lord. Let him do, my lord. Let him do and submit before your. lord.
I'm an
I have
only an
no objection.
amicus curiae.
I have no objection.
Well, ultimately, it's a PIN.
True, my lord.
Nobody's
Sir,
personal
from-
interest.
From
Well,
my,
I'll go alone.
from the,
I'll
from the.
go
from
with
the
my
dis-
junior.
From the district
No,
authority. my
They'll
lord.
also accompany.
Yes,
Why not?
they can offer their assistance there also in the.
Yes, yes,
site.
the officers are there, my lord. They are providing all the assistance to the amicus club.
मेरे को बुलाकर पूरा picture ले लेगा। What's wrong? Today, yes, no. এখন দেখুৱাব পাৰে হেৰি আৰু আছে মই আইপেডত আছে এইখনতো ৰাস্তাটো আছিল ন bottom floor.
Ms. Chaudhary, you see the concern of the court is as follows. This issue is a very disturbing issue because it has been brought to our notice that children are in difficulty without having shelter, etc.
iPad to put.
So what we expect from you is
Then
you make an inquiry through the apparatus of the legal service at the district level. Figure out what is the ground reality in Hojai as well as in other places. Then find out what are the schemes available under LANSA, if any, to take care of their interest. And then give us a feed as to what would be the way forward, the judicial orders that can be passed to ensure that a proper mechanism is in place to protect the interests of the children. So that is the broad scheme of things that we are looking into. For doing that, if necessary, the member secretary can pay a personal visit, accompany Mr. Kaur as he has desired. Beyond that, we are not saying anything. And Mr. Kaur, you can also bring on record
yes, man.
your
It's a nice
findings.
drive all the way to that.
No, that's all right. You enjoy your drive and whatever else. We are not concerned with those things. We are concerned with the issue and we'll focus only on that. Who goes where with whom, we are not concerned.
Incorrect to say that, what my learned friend is saying that the report is incorrect.
Hmm.
What they have said is that there is no designated shelter home.
It's not
Which is
shelter
what-
home, it's relief camp.
That is exactly
It's
what.
a-
in fact
it's a relief
there
camp
is no
because-
designated shelter home in the district of Punjab.
That,
which is what
that's the
report says.
reason, that's the
Yes.
reason we want
They have
to have the
concepts.
perspective of the legal service authority. So
At the
please,
time of eviction,
please put it on
Lordship,
in writing.
Well-
And Mr. Nath, you may also obtain your
Lordship,
instruction.
I'll definitely. What
We'll
the-
see what is the way forward and what is the best we can do for the
My
children.
lord,
That is the sole purpose of this PIL, nothing else.
Lordship, right? Definitely. Well, I'll get the instruction.
Learned counsel for the Assam Legal Services Authority and for the state of Assam has submitted that after filing of the present PIL, the situation in the temporary shelter homes has now been substantially improved. However, Mr. Kumar amicus curiae has contradicted the said position and has submitted that the situation in the condition in the temporary shelter homes, the condition of the children in the temporary shelter homes is not up to mark. Stop. Taking into consideration the above facts and circumstances of the case, we deem it appropriate to direct the Council for the Assam Legal Services Authority to take the latest, but to instruct the
We can make another.
respective DLSS, secretaries of the DLSS to take the stock of the situation in the shelter homes, particularly regarding the condition of the children, and thereafter submit a report before this court on the next date of hearing. In the meantime, the Council for the Assam State Legal Services Authority may also apprise the court regarding the various schemes of the National Legal Services Authorities as well as the state legal services authorities regarding the children. Will stop. Mr. Nath, counsel appearing for the state government, may also submit a report regarding the latest condition of the shelter homes before this court by the next date of hearing. Put up when? How much time?
4 weeks. First week of May.
First week of May, ki whatever the date, whatever.
Lordship.
And you may also submit whatever.
Yes, yes, I'll go and I'll inspect.
Item 6,
May it please your lordship. My lord, the matter relates to selection of a principal of a college, my lord. Now, the difference of mark is, my lord, 0.06. And our basic allegation is, my lord, in the interview component,
That issue, once the court has raised the flag regarding the incorrect minutes of the meeting, that has been resolved now.
my lord, on the last occasion, the matter was listed before, of course, another bench where this issue was raised by them. Instead, this honorable court felt that the records of selection should be called for. That is how the matter is placed.
Since you have raised the objection that this, if the more than 80% marks.
Yes,
and then
actually,
have
we
to give the
said,
reason-
we said 70%, they said it is 80%.
80%.
It is there. If it is 80%, then also, my lord, they are supposed to give reasons because your 90% was given.
Nahin, but this court has taken a very serious.
Yes, my lord.
regarding that, how you
Yes.
can
Lordship, may
place
I
on
just
record.
interrupt here for a moment? This matter was last week, it was heard and it was to be, judgment was to be delivered, number one. But before that, one order, Lordship, can you see, without going to the merit of the case, 11/10/2020.
Yes, sir, that is what only honorable lordship is
11
referring to.
11th October 2023. There was a paid document submitted in this case and this honorable court expressed the opinion.
Yes, sir, that is what the honorable court is referring to.
That is what I am.
On the date of this thing, this court shall consider initiating proceedings under section 340 CRPC against the applicant. The paid document was submitted here, paid minutes, and that has created all the problems. And therefore, the council of the APSC was directed to furnish the record in origin. And last week, the original records were also furnished before in court number 3. And hearing was already over.
From the order sheet, it is nowhere indicated that the hearing was already over.
2023 lot of it.
No, it is a fact, my lord. We filed an additional affidavit. We brought on record a a proceedings of the APSC where it was indicated, my lord, 70%. Now, the one they have produced is 80%. All right, my lord, we are guilty of producing a document which is not genuine. But what about your own conduct? When it is 80%, where is the reason?
The conduct, will consider their conduct. But
Yes.
if you are
No, my lord.
using some.
No, my lord, it's
document
not a
which is
fake document.
genuine,
It's, my lord,
Which is not genuine.
no, my lord.
then, Sir,
My lord, all is not well in APSC, my lord. I can only say this much. The chairman was in jail for 6 years. The members were in jail for several years. All is not well in APSC, my lord.
that doesn't mean that any fake.
No,
document
I'm
can
not,
be
I'm
produced
not
without-
saying that, my lord. I'm genuinely what I'm saying is, my lord. Yes, we filed an affidavit where we annexed a document which is verbatim same as everything, my lord. Only thing is, please come to that document, my lord.
Yes.
Yes. We filed the additional affidavit at page 174, my lord. Running page 174. নাই, এইটোৰ কেছত কিবা এটা হ'লে মই ভাল পাওঁ, বেলেগ কেছ বিলাকতো হ'ব। এইটো যদি এটা কিবা অৰ্ডাৰ হয়, তেতিয়া so many cases we can also face.
Everything is not well in the order is important here. Explanation cannot help. Yes.
Page 174, my lord.
Yeah.
Minutes of meeting of the commission held on 18/5/22 at 4:30 PM. Kindly see, my lord, Rajiv Kumar Bora was the chairman, etc. Now, first para, rationalization of marking in the Viva Voce. The meeting deliberated on the marks to be given by inter board members under general bearing and subject of knowledge in the Viva Voce, and observed that in some cases the marks recorded were relatively on the higher side. Although the APSC Conduct of Business Procedure Rule 19 is silent in spelling out any guideline on the matter, but considering the sensitivity of the issue, it had become necessary to deliberate on this matter in order to effect greater rationality and consistency in evaluation of the candidates appearing in the interview. The meeting opined that marking should be judicious after making a reasonable assessment of the candidate's personality and other attributes. And as such, it is considered to be appropriate that if the board members desire to give extremely high marks to any candidate that is 70% and above, the board should record the reasons to justify the award of such high marks. My lord, this is the document we annexed. Now they say this is a fake document only to the extent of the 70 is substituted by 80. Otherwise, my lord, the whole thing is same.
Sir, whatever it, 70 at two places.
Yes,
The 70% is mentioned at two
yes.
places. in
Now,
this
my lord, will
place
kindly
that-
come to the
which is the-
document which they placed.
Yes. which
Yes,
is the-
yes, yes. The documents which they placed, my lord, I think my learned friend has placed that before this honorable court. On the last occasion, copy was given to us. The counsel for the APSC produced that later. I think it was given furnished to the honorable court. It must be on the record.
Original record was placed on last week and it was returned back today.
Where is the original?
No, no, otherwise also, my lord, the copy was given. This is the copy. Only, my lord, 70 is 80, right? Rest everything is same.
Also, here it is 3 pages, the other document has 4 pages.
No, no, we gave only 1 page.
What is the explanation for that? What is the explanation?
What is your explanation regarding that?
My lord, my explanation is, now if my lord, this issue is to be taken to its logical end, then I would like to examine all these persons, my lord.
Certified to be true
No,
is
True.
certified by an advocate.
yes.
Yes.
My lord, our source of information is one member of the Public Service Commission.
Because it is reported.
Now we'll do.
175 paid. Kindly have a- 175.
My lord, they are shying away from the merits of the case.
Sir, whatever it may be, first of all, we'll have to settle this issue.
Yes.
sir.
Fine. Page 1 of 4. Nothing got it.
In the last,
Yes, 1 of 4. And the original nothing which I have produced nothing, it is only 3 pages. They have
that is the cut.
Dr. W.
However, the fact document has been produced report hampering the administration of justice by a principal, by a candidate who is vying for the post of principal. And it is the conduct and he is harping on the conduct of another. He will even submission has been made.
What is the original record?
So I have produced that 2 3 lordship, that original, the minus the voluminous, which was sent back to the APNT for recording further minus. I will put it at 2 PM if necessary.
That aspect of the matter is supposed to be there is.
My lord, there's one more thing, my lord, since my learned friend will be producing the records. If your lordship would kindly have the page 151, my lord. He should also produce that record, my lord,
151 is what?
of the memo of appeal, my lord.
That I have lordship, that I have.
Page 152.
What is it?
My lord, this is the, the mark sheet, my lord, where the interview, how it was recorded. Now, if your lordship will kindly come to serial number 7, my lord, interview program, maximum 20 on the left-hand side. If your lordship would kindly come to right-hand side, my lord, 1.5 and 1.18 is there.
Yeah.
As your lordship noticed that, my lord. That means that the appellant before a lordship was given 5 marks by this particular member called Jotin Sharma, my lord. And the private respondent was given 18, that means 90%. So if we go by their stand, my lord, that if it is 80%, then where the records, the reasons were recorded, that record should disclose.
That we will consider, Mr.
Yes,
Chaudhary, but
yes.
first of all, we are concerned
Yes.
that how a fake notice of meeting can be produced before this court. And on the basis of that, if you are seeking equitable relief,
No, my lord.
that is.
No,
That is.
No, my lord, if this matter is to be taken to its logical end, as the other side would like to do it, my lord, perhaps we may have to take some more actions in this case. Because then in that case, we'll say that I would like to examine all the members of this committee.
No, my lord, the matter will go to the magistrate, my lord. If your lordship is satisfied, matter will go to the
No, no, no.
magistrate there, my lord, they can hear.
No, no, no.
Yes.
That I understand, that I understand. Now, if your lordship is, thinking in terms of that, possibly, my lord, those steps we'll have to take. And we'll have to disclose the person who has given us this document.
Maybe sir, even though if you are not disclosing, these are the court proceedings.
No, my lord.
No. You can't even,
No, yes,
Let us see.
I'm not saying, correct, my lord, court proceedings should not be taken to such an end. But then, my lord,
it's
sometimes,
a
my
matter of
lord,
trust, sir. It's a matter of trust.
correct.
And if in the court proceedings, if some document, fake document is produced, and then you are insisting on that, and the.
No, my lord,
appellant is
it's not
insisting
a
on
question
that,
of, it's not a
even
question
though
of,
if it is
my
there,
lord, one
we may-
citizen may bona fide believe in the genuineness of a document, my lord.
This is perjury, my.
So bona fide belief and something certified to be true, until and unless you have the original before you, how can you certify it to be a true?
My lord, the original was there. The photocopy of that document was there. That we have checked up. Anyway, my lord, whether APSC stand is correct or not, that also lordship will get to know from the records.
Let us see. Two.
Supplementary list, item 28.
My lords, I beg to appear in item 28, if my lords, I'm audible and visible to my lords.
Yes.
Now, this is a matter of a very serious importance for the place precisely. To begin with, I must inform this Honorable Court that we filed initially a petition before the Honorable Supreme Court, my lords.
Yeah, we are aware of that.
I'm grateful, my lords. And the Honorable Court has granted us liberty, and the view was that the High Court would be better placed and better equipped with the topography and the importance of the place, my lords. Now, my lords are aware that Kamakhya temple has its own importance, not only nationally, but internationally. Now, this corridor, which is proposed by the government, and the PWD, my lords, the department is involved for the purpose of construction. The cause of action for us to, my lords, get worried and file the petition occurred, my lords, when a post was put up on a social media platform. Earlier it was known as Twitter, and later on, my lords, now X, by the Honorable Chief Minister of the state. And a 4 minutes video was placed, my lords, posted. We have, my lords, at Annexure 5, placed a later post, my lord. That was an error on our part, but I have requested my friends over there to place before my lords a video of 4 minutes. It's a huge level of construction which is supposed to be carried out to the 3 times of the area, my lords, available there. As of now, the area which is there with the Kamakhya temple, my lords, 3 times of that area have to be, my lords, covered. Basement has to be also constructed, and that means there has to be excavation. They want to build up floors, my lords. So it has to go from basement, ground floor, upper floor, or at certain places. They want to broaden up the staircases, which leads to the main Kamakhya temple.
So you mean to say that your main concern is that that the original, whatever the original structure, that should not be disturbed. This is what your concern, main concern.
My lords are very right. Our major concern is this, that this is not a temple where deities have been manually created and installed, and therefore even if there is some damage, we can reinstall another statue. These are naturally, these are natural deities, my lords. We have in natural water springs, and they are considered as deity and given different names of the Mahavidyas.
Fine.
Only two of them are statue. Rest of them, my lords, are natural water springs. We do the sparsh darshan. So the worshippers must do touch the water, and that is considered as touching the feet of the god.
Fine.
Now, lords, any damage, any excavation, any broadening of the thing, lords, we have a serious concern as worshippers that it should not cause damage to the
Original structure.
I'm so very grateful, my lords. And so we are not coming in the way of lords development. Everybody would welcome that, but let them place a white paper, let them assure us, let them address our apprehension.
Yes. That's why only we have issued notices
Yes.
on that occasion. Yes, what is your response from the state?
My lords would have to issue notice, my lords.
It is for the first time, if I am not wrong, Lordship.
Yes,
Okay.
yes. It has come up before, my lords. There was some error, so we had carried out
No,
some.
Mr. Dole, learned council chair furnish a copy of it. Standing council of PWD, we have already furnished copy to the.
Copy we have received, Lordship, so we'll file a response, Lordship. And whatever their apprehension, Lordship, everything will be well taken care of. I assure this honorable court.
Well, taken care of in the reply or in practical?
In practical also.
Okay.
And also in the reply also, because they are only apprehending. The
Whatever it may
apprehension
be,
is there.
their
We are more
apprehensions-
concerned about those
Their
apprehensions.
apprehensions are genuine, and if you are able to satisfy them,
Yes,
that yes, we are not going to do what exercise they are apprehending.
I fully agree, Lord.
Click here. Having heard the learned counsel for the petitioner for quite some time, we deem it appropriate to issue notice to the state. Mr. D. Sekia, learned advocate general, accept notice on behalf of all the respondents. He cannot accept. Mr. D.
There is government of India also, madam.
Pending counsel, preparing for the state of Assam. State of Assam.
That's all the respondents.
At this stage, my humble submission, only to respondent number 5 will do, Lordship, at this stage. If
Why? How many respondents are there?
there are 8 respondents,
Union of India, Ministry of
tourism, central government, then archaeological, then chairman divine, PM divine scheme. Because the Assam government is taking up. this.
Three would be very relevant. Three would be very relevant. Archaeological Survey of India.
Let the response of the state government become, then if it required, then certainly will issue notice to the other respondents also.
I would only be praying for an interim direction.
What interim direction, ma'am?
Let them not to proceed further
No.
before. Once they proceed further, then nothing would remain.
Let their response become, and if we.
It is not going to be done in one day.
To change some, there are some material changes, then certainly we can pass a interim order at this stage. But
Look,
here
they may
let-
proceed.
let-
They may
let their
proceed
response-
with the rest of the aspects of the project, except any demolition, any excavation.
That will grant them only 2 weeks' time. Within 2 weeks, I don't think so. Anything else.
My lords, please.
My lord, may I supplement, Ms. Gupta? There, my lord, the Archaeological Survey of India and the donor ministry, which have made party, are very important because without their authority, the state government cannot proceed further.
So certainly they'll file a response
Yes,
regarding that,
yes.
that they are, say,
They
that
cannot
they
do
have
it.
permission from the Archaeological of India or whatever it may be.
Yes.
Let the
That
state.
is the donor ministry, my lord, who is
Ultimately,
to
the
take up the
executing
construction.
agency is the state.
Yes.
Executing agency is the state. So let them file their.
My lord, I am told, my lord, demolition is going on. Let them not do it. Because every rock is
Code
one incident.
And what is the reality?
Yes.
Let them file their response. Consider.
2 weeks, my lord.
Having heard the concept of the petitioner, we deem it appropriate to issue notice to the state of Assam, Mr. D. Nath. We'll do one thing, the 5, 6, 7 and 8.
I would be requesting 3 as well, my lords.
Where this Department of Cultural Affairs, Department of Tourism.
These
Public
all
Works,
comes under state of Assam.
I would say 3. This
Because
point
our
number 3 as
affidavit
well.
will,
The state of Assam file their response to the writ petition, Mr. D. Nath, accept notice on behalf of the state of Assam. 2 weeks time is granted to file the response. Just after 2 weeks view vacation, just after view vacation.
22nd, Lordship, if it is convenient.
Any
22nd.
Tuesday, I would be requesting any Tuesday. minutes.
Any Tuesday. Okay. Then
23rd,
23rd,
As my lords please, my lords may issue notice on the interim application as well.
23rd, I have to go to NGT Calcutta, Delhi, Lordship, 23rd. So either 22nd or 29th, or maybe 30th.
So let it be better, my lord, bit early, my lord, let it 22nd. 22nd, bit early.
22nd?
Yes.
Yes.
Yes, ma'am.
Lords,
22nd.
I'll manage, my lords, I'll appear. My lords may kindly issue notice on the interim application as well.
We are already seized of the matter. If any requirement is there, without even issuing notices for interim application, we can pass
It does help, my lords.
No, nothing.
Lordship, we are more concerned about the temple and all its heritage.
Mr. Sharma,
It is shown, my lord,
Mr. Sharma.
very, my lord, display picture.
Mr. Sharma, I was just going through the petition.
Yes.
It just came to my mind. I'm just putting it to you on behalf of the bench. Of course, Kamakhya, deity of Kamakhya is one of international obeisance from parts of the world. There's no doubt about it. But nobody from Assam, almost nobody from Assam, and no one who is living in the vicinity of the temple has any complaint about it. That's what we find.
Petition number 1 is the, my lord, she's the daughter of one of the pandas there earlier then. Petition number Gitika Bhattacharya is from Assam only.
Only one.
One.
That's
Others
the
are
only
from,
one.
experts from India. Because it is concern not of the Assam only, not of the Guwahati, my lord, but it is the concern of the national communities and the other international communities also.
I wish they had highlighted the construction of hotels and all in the peripheries. They are not concerned about that.
We have highlighted the picture. They have
This is
given.
not an adversarial petition.
I understand.
We all would be concerned about
the
it.
deities and the heritage. We are more
No, we-
concerned. It is
Yeah,
our
we-
heritage. Although
Let's
you
not
may
have a
come from different
competition who
parts
is
of the
more
country,
concerned.
but Guwahati
We all
is
should be
pride of
concerned
Kamakhya.
about it.
1960 when the present road was constructed, a lot of care was taken because otherwise it was not allowed to be constructed then. Because I was in school then, we used to go to
Let them file their
walking,
response
yes.
and consistent.
Obliged.
Highly obliged. Lord.
Great for minutes.
Item 29 to 31.
Yeah, please, your lordship, lordship in this matter as per the order dated 24th of August 2023, your lordship, a census report was directed to be filed regarding those districts where encroachment has been identified in the tribal belt and blocks of Assam, your lordship. Regarding that, your lordship, I have received instructions only of Kamrup Metro, Kamrup Rural and Udalguri district. I'm still awaiting my instructions for the rest of the 4 districts, your lordship.
So 24th of August 2023.
Yes, your lordship,
Still you
because
are
it's a
waiting for the
census.
instructions.
I understand, your lordship.
No, I
because
think on,
it's-
no, 12 to 24.
That was the last order, but it was regarding the census report. So I received instructions regarding only 3 districts, your lordship.
That is your headache, madam. We need report from all the districts.
Yes.
Why you have not been able to collect the reports from all the districts?
In fact, on 12 to 24, my lord, 6 weeks time was granted.
The last time.
Last time to look on again. Naikwa. Naikwa. Good. Naikwa.
Borrowed.
Huh?
Last opportunity.
On the last occasion, we have observed this, that much time was already granted. And again, you are asking for more time. Who is the person responsible for all this?
Last
Lordship, the
opportunity.
To
revenue
furnish the report? Who is the
So
person?
one last chance may be given. I'll take interest, Lordship.
It's August 2023, the order was given
Lordship.
and still you are collecting the information. That's not the.
In fact, at one time, Lordship, this matter was to be disposed of on that day itself, if I am not wrong.
Ultimately, it's pending.
Ultimately, it came.
It is pending now.
So one last opportunity may be given to us, Lord.
Okay. Mr. M. Bordoloi. Learned Senior Standing Council Revenue and Disaster Management Department. Standing Council, sorry. Standing Council for Revenue and Disaster Management Department, Assam. Raise some more time to furnish the report. On last occasion, on 12/2/2024, this court has taken into consideration the fact that much time was already granted to the respondent to furnish the report. However, a last opportunity of 6 weeks was granted to furnish the report, furnish the desired report. Full stop. The Advocate General, Mr. D. Sekia, appearing on behalf of the respondent, has submitted that the report would be furnished before this court. The desired report would be furnished before this court by the next date of hearing positively. Which date now you want?
Conveniently, immediately after 15th of May, Lordship. Because there is an election process going on. By 7th, it will be over in Assam. All the deputy commissioner, they are all becoming returning officers and all. So if it is taken any day,
Give us the date.
Better be first week of June, my lord.
no, if we take a very long date, it gets very casual, everybody. So I want it will be 16th or 17th of May, Lordship.
17th of May.
17th of May.
So for relating to item number 31 is concerned, my lord, I filed an application for vacating the interim order listed 2644/2021. It was filed on 6/12/2021, my lord. It was not disposed of for 3 years, my lord. Thing is simple, my lord, one factory.
Now, what is the urgency in disposing of today itself?
My humble submission for your lordship is that, my lord. In this case, one of them is under section 160, subsection 2, my lord. As categorically said, non-liable who cannot transfer into the purpose of the land. And this factory has been set up, my lord, in the land. And they have projected another land in the case, my lord, and acquire our land, my lord. There is an order from the circle officer, there from the order from the deputy commissioner, there is the order from the Board of Revenue order, my lord. Board of Revenue order was not challenged before this court, my lord. And got the interim order, my lord, and due to that interim order, that land has been possessed, my lord. My humble submission is that petition shall be disposed of, my lord.
Next date. You consider on the next date, we will certainly consider this application for vacation of stay. Let them furnish a report. So we have.
Is something different, my lord. Report is they want to submit a report in the state of private building form. My case is that idea there is an order, my lord. Subsequent they can submit the report, my lord. But this private building block, my lord.
Certainly, they'll also report regarding your position of your land also in the report.
My humble submission is not that, my lord. When the my case has been come, my lord. In the second report, there is no any order has been passed, my lord. So subsequent any order has been come, my lord. That will be affected by my case, my lord. But my petition will be disposed of, whether he can entitle for that or not.
Let us see.
Because civil code is barred, my lord.
Mr. Counsel, please, let them consider. First, their furniture report will consider on that day. Your application also on merits. If there is any. Will not wait for their report.
My lord, the interim order will have to be extended in this.
That is the
Interim order. We have to extend it.
My state again, I think that's a 3 years.
Let us interim order if any is extended
Yeah.
till next date.
That is the last time.
We'll try to.
But the writ petition is of 21. How come my land is 3 years? I don't think it's 3 years.
6/12/2020, your lordship.
If we have filed an application, certainly it is required to be.
26,
It is desired to get the application decided at the earliest. Yes.
Daily list for hearing, item 7 and 8.
Make me your lord. My lord, this matter pertains to reservation and promotion. In fact, my lord, your lordship heard the matter about an hour earlier. The first question, my lord, that came for consideration before your lordship was, my lord, since the petitioner is, my lord, a society, whether a reputation will lie. Perhaps, my lord, on that your lordship was satisfied because of two facts, my lord. The earlier writ petition filed by the same party was entertained by this honorable court, and there, my lord, reasons were recorded. And secondly, my lord, there is another writ petition connected, my lord, making the same challenge where that question does not arise. Therefore, my lord, I'd like to proceed on merits, my lord. Only one thing, my lord, I'd like to say, this will take some time. Your lordship has a lot of matters today. Your lordship may take up at the last as the last item. Otherwise, that is one of the options, my lord, available, or I can start, my lord.
As you wish, we don't have any problem. We have to hear this case or other cases. we have to
My
hear
lord.
for that.
Then I start, I
Even
proceed.
though if you want hear now, then we are ready.
Now, my lord, the act, the provision of the act which has been challenged is, my lord, Assam Scheduled Castes and Scheduled Tribes Reservation of Posts in Services Act 1978. Although the Act is of 1978, there was an amendment in 2012. And this writ petition was filed, my lord, for challenging that amendment, and also the, my lord, primary act in 2013. This is a 2013 writ petition, my lord. The offending provisions, may I, my lord, bring to your lordship's notice. Section 5. Section 5, my lord. Page 254 in this book. 254. May I read, my lord?
Just a minute.
Reservation for scheduled castes and scheduled tribes in posts to be filled up by promotion. Reservation for members of scheduled castes and scheduled tribes in posts to be filled up in promotion by promotion in any establishment shall be regulated in the following manner, namely, there shall be reservation at 7% for members of the scheduled caste, 10% for the members of the scheduled tribe plains, and 5% for the members of the scheduled tribe hills, provided that the state government may, from time to time, review the implementation of the reservation policy and take adequate measures, including increase of percentage mentioned in this clause. Now, my lord, this B, clause B, this has been inserted by 2012 amendment.
Yes.
A separate post-based roster for recruitment and promotion for each cadre shall be maintained by every establishment for reservation of candidates of scheduled castes and scheduled tribes as contained in clause A of section 1. Then your lordship may kindly read section 5A, which has been also inserted in 2012 by this amendment of 2012. Manner and procedure for giving effect of reservation. The reservation for the members of the scheduled castes and the scheduled tribes in services or posts in any establishment shall be given effect to in the following manner, namely, a post-based roster register shall be maintained to give effect to the reservation of vacancies for scheduled castes and scheduled tribes. Such roster shall be based on the model roster as per Schedule 1 and 2 appended to this Act and shall be adopted for the purpose of each establishment in such manner that the prescribed percentage of reservation is maintained in each cadre. Each appointing authority shall prepare and notify roster based on the principles laid down in this Act and maintain roster register in a manner containing such number of points, so and so, so and so. Your lordship may skip the rest. My lord, we are aggrieved by this primarily because of the fact that, my lord, now the manner and procedure for giving the reservation in promotion has been given, and our case is that in view of the dicta laid down by the Honorable Supreme Court, you cannot have reservation in promotion until and unless you have the quantifiable data on the inadequacy of representation and efficiency of administration And based on that, the state forms an opinion whether reservation is required or not
In promotion.
in promotion. In promotion. That is our case. Therefore, my lord, I'll be relying on the decision of the Supreme Court based on which, my lord, our case stands. Where, my lord, in fact, your lordship knows, my lord, in appointment and promotion, reservations were already there, my lord, from earlier point of time. And in 1962, my lord, the NF Railway, sorry, my lord, the Railways case, 1962, the party is GM Southern Railway, that was affirmed by the Honorable Supreme Court. That the reservation can be there at the stage of appointment as well as in promotion. But in 1992, in the Indra Sahni's case, the Honorable Supreme Court has held that you can have reservation in initial appointment, but you cannot have reservation in promotion. However, Indra Sahni's case also said that the promotion that has already been done, that will not be interfered. That was in 1992. Thereafter, my lord, several amendments came to the Constitution. One is 77th Amendment, that was in 1995, where, my lord, Article 16(4)(a) was inserted. I'll take your lordship to the, my lord, Article 16(4)(a).
Yeah.
Then, my lord, in 2000, there was another amendment, 81st Amendment, where, my lord, overall ceiling of 50% was confined to current vacancies and unfilled reserve vacancies would be carried forward. So carry forward principle was, my lord, that was brought in the Constitution by 81st Amendment. Then in 2001, there was another amendment, 82nd Amendment, which provides for relaxation of qualifying marks, that is lowering the standard of evaluation in matters of reservation and promotion for the reserve category candidates. And in 2001, there was another amendment, 85th Amendment, where clause 16(4)(a) was amended, giving consequential seniority with effect from 17/8/1995. All these amendments came to be challenged in M. Nagaraj's case. And, my lord, the judgment in M. Nagaraja came in 2006. And after, my lord, examining all these amendments, eventually, my lord, the Honorable Supreme Court has said that these amendments are valid. But then, my lord, some riders have been given as to, my lord, which are to be qualified for and which has to be taken before making any reservation. So I'll primarily rely on the judgment of M. Nagarajan. And thereafter, my lord, there are subsequent cases which may not be very relevant, except perhaps, my lord, Jarnail Singh's case, where, my lord, the M. Nagaraja said, my lord, the basic principle which was laid down is that before you go for reservation, you have to have quantifiable data on backwardness, then efficiency in administration, and then adequate representation. Now, in Jarnail Singh's case, the first requirement of the quantifiable data on backwardness, that has been done away with. It has been held that they are backward, that has already been identified, therefore there is no quantifiable data required to come to a finding whether particular classes, my lord, backward or not. So that was gone. So two requirements, my lord, the representation, adequacy of representation, and efficiency of administration, that remains. But then, my lord, it has also been, my lord, that's been reiterated in V.K. Pavitra's case, first case 1 and V.K. Pavitra case 2. I'll take your lordship to that, which says that the state has to form an opinion on the basis of the quantifiable data, and without forming the opinion, you cannot have the reservation in promotion. Therefore, my lord, I'll first take your lordship to the provisions of the Constitution, Article 16(4) and 4(a). Article 16 is, my lord, equality of opportunity in matters of public employment. there shall be equality of opportunity for all citizens in the matter relating to employment or appointment to any office under the state. Number two, no citizen shall, on ground only on religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible for discriminated against in respect of any employment or office under the state. Then three, nothing in this article shall prevent the parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government of or in a local or other authority within a state or union territory, any requirement as to the residence with that state or union territory prior to such employment or appointment. Then, my lord, Article 16(4) and 4A will be important. Nothing in this article shall prevent the state from making any provision for reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, is not adequately represented in the service of the state. So adequacy, my lord, comes herein. 4A, nothing in this article shall prevent the state from making any provision for reservation in matters of promotion with consequential seniority to any class or classes of posts in the services under the state in favor of the scheduled castes and the scheduled tribes, which in the opinion of the state, I'm stressing, my lord, in the opinion of the state, are not adequately represented in the services under the state. Now, my lord, in this context, perhaps, my lord, it will also be relevant to bring to your lordship's notice, my lord, Article 335. Claims of scheduled castes and scheduled tribes to services and posts.
325,
335.
335.
My lord. The claims of the members, may I read, my lord? The claims of the members of the scheduled caste and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in the making of appointments to the services and posts in connection with the affairs of the union or of the state, provided that nothing in this article shall prevent the making of any provision in favor of the members of the scheduled caste and the scheduled tribes for relaxation in qualifying marks in any examination or lowering the standard of evaluation for reservation in matters of promotion to any class or classes of services or posts in connection with the affairs of the union or of a state. Now, my lord, after taking into consideration all these, the ratio that has been laid down in M. Nagaraja's case is that, my lord, these amendments are valid, but then Article 16(4) and 4A are only enabling provision. This enables the government to make provision for reservation, but then for making that provision, you have to have the quantifiable data. On, my lord, now two aspects remain, and thereafter form an opinion.
First is adequacy in representation and another is?
Another is, my lord, efficiency in administration. Now, although I'll, my lord, come to the case laws later on, in Vicky Pavitra's case, my lord, a challenge was made to the particular act that in the way, my lord, we are challenging. And Vicky Pavitra won, my lord, the act was set aside. Thereafter, my lord, the state of Kerala, state had collected the quantifiable data and thereafter provided for reservation after forming an opinion. That was against challenge. And this time, my lord, the Honorable Supreme Court did not interfere, my lord. But then, my lord, some observations are made. I'll take your lordship to those observations also. Now, my lord, I'd like to read certain paragraphs of the M. Nagaraja's judgment. Please, para 43, 46. My lord, I'll start from
Just a
I'll read my lord 5, 6 paragraphs, my lord, which will be relevant. My lord, I'll not read the entire judgment. My lord, the Honorable Supreme Court has, my lord, discussed certain backgrounds which may be necessary, my lord, for your lordship's consideration. Paragraph 43. This discussion is important because in the present case, we are concerned with the reservation. Balancing a fundamental right to property vis-a-vis Article 39B and 39C in Keshavananda Bharati and Minerva Mills cannot be equated with the facts of the present case. In the present case, we are concerned with the right of an individual to equal opportunity on one hand and preferential treatment to an individual belonging to a backward class in order to bring about an equal level playing field in the matter of public employment. Therefore, in the present case, we are concerned with conflicting claims within the concept of justice, social, economic, and political, which concept, as stated above, exists both in Part 3 and Part 4 of the Constitution. Public employment is a scarce commodity in economic terms. As the supply is scarce, demand is changing the commodity. This is the reality of life. And the concept of public employment, unlike the right to property, is socialistic and therefore falls within the preamble to the Constitution, which states, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic." Similarly, the preamble mentions the objective to be achieved, namely justice, social, economic, and political. Therefore, the concept of equality of opportunity in public employment concerns an individual, whether that individual belongs to the general category or backward class. The conflicting claim of individual rights under Article 16(1) and the preferential treatment given to a backward class has to be balanced. Both the claims have a particular object to be achieved. The question is of optimization of these conflicting interests and claims. Then paragraph 44. The above three concepts are independent variable concepts. The application of these concepts in public employment depends upon quantifiable data in each case. Equality in law is different from equality in fact. When we construe Article 16(4), it is equality in fact which plays the dominant role. Backward classes seek justice. General class in public employment seek equity. The difficulty comes in when the third variable comes in, namely efficiency in service. In the issue of reservation, we are being asked to find a stable equilibrium between the justice and the backwards, equity for the forwards, and efficiency for the entire system. Equity and justice in the above context are hard concepts. However, if you add efficiency to equity and justice, the problem arises in the context of the reservation. This problem has to be examined, therefore, on the facts of each case. Therefore, Article 16(4) has to be construed in the light of Article 335 of the Constitution. Inadequacy in representation and backwardness of the scheduled castes and scheduled tribes are circumstances which enable the state government to act under Article 16(4) of the Constitution. However, as held by this court, the limitation on the discretion of government in the matter of reservation under Article 16(4) as well as Article 16(4)(a) come in the form of Article 335 of the Constitution. Merit is not a fixed absolute concept. My lord, this, your lordship may skip paragraph 45 and come to paragraph 46. The point
which we are emphasizing is that ultimately the present controversy is regarding the exercise of power by the state government depending upon the fact situation in each case. Therefore, vesting of the power by an enabling provision may be constitutionally valid, yet the exercise of power by the state in a given case may be arbitrary, particularly if the state fails to identify and measure backwardness and inadequacy, keeping in mind the efficiency of service as required under Article 335. Then your lordship may kindly come to paragraph 86.
Yes.
Paragraph 86. Clause 4A follows the pattern specified in clause 3 and 4 of Article 16. Clause 4A of the Article 16 emphasizes the opinion of the state in the matter of adequacy of representation. It gives freedom to the state in an appropriate case depending upon the ground reality to provide for reservation in matters of promotion to any class or classes of posts in the service. The state has to form its opinion on the quantifiable data regarding adequacy of representation. Clause 4A of Article 16 is an enabling provision. It gives freedom to the state to provide for reservation in matters of promotion. Clause 4A of Article 16 applies only to SCs and STs. The said clause is carved out of Article 16.4. Therefore, Clause 4A will be governed by the two concepts compelling reasons, backwardness and inadequacy of representation as mentioned in Article 16.4. If the said two reasons do not exist, then the enabling provision cannot come into force. The state can make provision for reservation only if the above two circumstances exist. Further, in Ajit Singh 2, this court has held that apart from backwardness and inadequacy of representation, the state shall also keep in mind the overall efficiency, Article 335. Therefore, all the three factors have to be kept in mind by the appropriate government in providing for reservation in promotion for SCs and STs. Then, my lord, your lordship may kindly come to paragraph 107.
Yes.
107. It is important to bear in mind the nature of constitutional amendments. They are curative by nature. Article 16.4 provides for reservation for backward classes in cases of inadequate representation in public employment. Article 16.4 is enacted as a remedy for the past historical discrimination against a social class. The object in enacting the enabling provision like Article 16.4, 16.4A, and 16.4B is that the state is empowered to identify and recognize the compelling interests. If the state has quantifiable data to show backwardness and inadequacy, then the state can make reservation and promotion. Keeping in mind maintenance of efficiency, which is held to be a constitutional limitation on the discretion of the state in making reservation as indicated by Article 335. As stated above, the concept of efficiency, backwardness, inadequacy of representation are required to be identified and measured. That exercise depends on availability of data. That exercise depends on numerous factors. It is for this reason that the enabling provisions are required to be made because each competing claim seeks to achieve certain goals. How best one should optimize these conflicting claims can only be done by the administration in the context of local prevailing conditions in public employment. This is amply demonstrated by the various decisions of this court discussed herein above. Therefore, there is a basic difference between equality in law and equality in fact. See, affirmative action by so-and-so William Garrity in Article 16.4A, 16.4B flow from Article 16.4. And if Article 16.4 is an enabling provision, then Article 16.4A and 16.4B are also enabling provisions. As long as the boundaries mentioned in Article 16.4, namely backwardness, inadequacy, and efficiency of administration are retained in Article 16.4A and 16.4B as controlling factors, we cannot attribute constitutional invalidity to these enabling provisions. However, when the state fails to identify and implement the controlling factors, then excessiveness comes in, which is to be decided on the facts of each case. In a given case where excessiveness results in reverse discrimination, this court has to examine individual cases and decide the matter in accordance with law. This is the theory of guided power. We may once again repeat that equality is not violated by mere conferment of power, but it is breached by arbitrary exercise of power conferred. Your Lordship may come to paragraph 110. The test to judge the validity of impugned state act. As stated above, the boundaries of the width of the power, namely the ceiling limit of 50%, the numerical benchmark, the principle of creamy layer, the compelling reasons, namely backwardness, inadequacy of representation, and overall administrative efficiency, are not obliterated by the impugned amendment. At the appropriate time, we have to consider the law as enacted by various states provided for reservation if challenged. At that time, we have to see whether limitations on the exercise of power are violated. The state is free to exercise its discretion of providing for reservation subject to limitation, namely that there must exist compelling reasons of backwardness, inadequacy of representation in a class of post, reasons of backward. I'm sorry, Madam.
Keeping in mind the overall.
Keeping in mind the overall administrative efficiency. I'm sorry. It is made clear that even if the state has reasons to make reservation, as stated above, if the impugned law violates any of the above substantive limits on the width of the power, the same would be liable to be set aside. Then paragraph 117. This is regarding forming on opinion by the state. 117. The test for judging the width of power and the test for adjudicating the exercise of power by the state concerned are two different tests which warrant two different judicial approaches. In the present case, as stated above, we are required to test the width of power under the impugned amendments. Therefore, we have to apply the width test. In applying the width test, we have to see whether the impugned amendments obliterate the constitutional limitation mentioned in Article 16.4, namely backwardness and inadequacy of representation. As stated above, these limitations are not obliterated by the impugned amendments. However, the question still remains whether the state concerned has identified and valued the circumstances justifying it to make reservation. This question has to be decided case-wise. There are numerous petitions pending in this court in which reservations made under the state enactments have been challenged as excessive. The extent of reservation has to be decided on the facts of each case. The judgment in Indra Sahni does not deal with constitutional amendments. In our present judgment, we are upholding the validity of the constitutional amendments subject to the limitations. Therefore, in each case, the court has got to be satisfied that the state has exercised its opinion in making reservation in promotion for SCs and STs, and for which the state concerned will have to place before the court the requisite quantifiable data in each case and satisfy the court that such reservations become necessary on account of inadequacy of representation of SCs and STs in a particular class or classes of posts without affecting general efficiency of service as mandated under Article 335 of the Constitution. Then, my lord, the concept of creamy layer has also been, my lord, discussed in paragraph 120. At this stage, one aspect needs to be mentioned. Social justice is concerned with the distribution of benefits and burdens. The basis of distribution is the area of conflict between rights, needs, and means. These three criteria can be put under two concepts of equality, namely formal equality and proportional equality. Formal equality means that the law treats everyone equal. Concept of egalitarian equality is the concept of proportional equality, and it expects the state to take affirmative action in favor of disadvantaged sections of the society within the framework of democratic polity. In Indra Sahni, all the judges except Pandian J feel that means test should be adopted to exclude the creamy layer from the protected group earmarked for reservation. In Indra Sahni, this court has therefore accepted the case caste as a determinant of backwardness, and yet it has struck a balance with the principle of secularism, which is the basic feature of the Constitution, by bringing the concept of creamy layer. Views has often been expressed in this court that caste should not be the determinant of backwardness, and that the economic criteria alone should be the determinant of backwardness. As stated above, we are bound by the decision in Indra Sahni. The question as to the determinant of backwardness cannot be gone into by us in view of the binding decision. In addition to the above requirement of court in Indra Sahni has evolved numerical benchmark like ceiling limit of 50% based on post-specific roster, coupled with concept of replacement to provide immunity against the charge of discrimination. Then, my lord, 121. Sorry.
Yeah.
Then conclusion at paragraph 121. The impugned constitutional amendments by which Articles 16.4a and 16.4b have been inserted through from Article 16.4, they do not alter the structure of Article 16.4. They retain the controlling factors or the compelling reasons, namely backwardness and inadequacy of representation, which enables the state to provide for reservation, keeping in mind the overall efficiency of the state administration under Article 335. These impugned amendments are confined only to SCs and STs. They do not obliterate any of the constitutional requirements, namely ceiling limit of 50%, quantitative limitation, the concept of creamy layer, that is qualitative exclusion, the subclassification between OBCs on one hand and SCs and STs on the other hand, as held in Indra Sahni, the concept of post-based roster with inbuilt concept of replacement as held in R.K. Sabharwal. Then 122, we reiterate that the ceiling limit of 50%, the concept of creamy layer, and the compelling reasons, namely backwardness, inadequacy of representation, and overall administrative efficiency, are all constitutional requirements without which the structure of equality of opportunity in Article 16 would collapse. 123. However, in this case, as stated above, the main issue concerns the extent of reservation. In this regard, the state concerned will have to show in each case the existence of compelling reasons, namely backwardness, inadequacy of representation, and overall administrative efficiency before making provision for reservation. As stated above, the impugned provision is an enabling provision. The state is not bound to make reservation for SCs and STs in matters of promotion. However, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing backwardness of the class and inadequacy of representation of their class in public employment, in addition to compliance with Article 335. It is made clear that even if the state has compelling reasons, as stated above, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling limit of 50% or obliterate the creamy layer or extent of reservation indefinitely.
Just a minute, Mr. Chairman.
Mike.
Yeah, I'm saying 2006 criteria laid down here. This is my 1978 act was spectrum. My 25 data that we have requirement happening. 25 is data coupling. Yeah, that's a it's and the UI. If we don't need to not. Amendment जो लाया है. This amendment is
Inter factor 9 जो रहती है सर तो मतलब 9 जब नहीं
12 minutes. No, but this is about the manner of. They are asking striking down on section 5.
Just question है interest कैसे
Section 5, sir. Section. Use the section 5. Manner of But five reserves of five is different.
Now, may I take your lordship to the Jordan Singh's case, my lord? 2018 10 SCC 396. Ahmedabad is a five judges consideration bench, and this Jordan Singh is also my lord five judges consideration. In paragraph 19, the board has noticed,
19,
paragraph 19,
19.
the Honorable Supreme Court has noticed the
Just,
finding.
just let us. Yes.
My lord, I'll read paragraph 19, 23, 25, 26, 28, 30, 35, and 36. These are the
One by
paragraphs I'll
one.
read now. In paragraph 19, my lord, the conclusions
That have been recorded.
that has been, my lord. Notice your lordship has, my lord, I have read it already. I will not take your lordship's time. Then your lordship may kindly come to paragraph 23.
23. Yes.
This brings us to whether the judgment in Nagraj needs to be revisited on the other grounds that have been argued before us. In so far as the state having to show quantifiable data as far as backwardness of the class is concerned, we are afraid that we must reject Sri Shanti Bhushan's argument. The reference to class in the East to the scheduled caste and scheduled tribes and their inadequacy of representation in public employment. It is clear, therefore, that Nagraj has, in unmistakable terms, stated that the state has to collect quantifiable data showing backwardness of the scheduled caste and the scheduled tribes. We are afraid this portion of the judgment is directly contrary to the 9-judge bench in Indrasani. Jivan Reddy, speaking for himself and 3 other learned judges, had clearly held the test or requirement of social and educational backwardness cannot be applied to the scheduled caste and scheduled tribes who indubitably fall within expression backward class of citizens. So referring to that, eventually it was held that that requirement of collection of quantifiable data will not be there. Then your lordship may read my lord paragraph 26. I'll read further, my lord. Equally, Dr. Justice Thompson, in conclusion at para 324 has held as follows. Only such classes of citizens who are socially and educationally backward are qualified to be identified as backward classes. To be accepted as backward classes for the purpose of reservation under Article 15 or Article 16, their backwardness must have been either recognized by the means of a notification by the President under Article 341 or Article 342, declaring them to be scheduled caste or scheduled tribe, or on an objective consideration identified by the state to be socially and educationally so backward by reason of identified prior discrimination and its continuing ill effects as to be comparable to scheduled castes or scheduled tribes. In case of scheduled castes and scheduled tribes, these conditions are, in view of the notification, presumed to be satisfied. Then in paragraph 25, however, when it comes to creamy layer principle, it is important to note that this principle sounds in Article 14 and 16(1) as unequals within the same class are being treated equally with other members of that class. The genesis of this principle is to be found in State of Kerala versus N.M. Thomas. This case was concerned with the test relaxation rule in promotion from lower division clerk to upper division clerk by a 5:2 majority judgment. The said rule was upheld as a rule that could be justified on the basis that it became necessary as a means of generally giving a leg up to backward classes. Then in paragraph 124, Justice Krishna Iyer opined, a word of sociological caution. In the light of experience here and elsewhere, the danger of reservation, it seems to me, is threefold. Its benefits, by and large, are snatched away by the top creamy layer of the backward caste and class, thus keeping the weakest among the weak always weak, and leaving the fortunate layers to consume the whole cake. Secondly, this claim is overplayed by extravagantly in democracy by the large and vocal groups whose burden of backwardness has been substantially lightened by the march of time and measures of better education and more opportunities of employment, but wish to wear the weaker section label as a means to score over their near equals formally categorized as upper brackets. Lastly, a lasting solution to the problem comes only from improvement of social environment, added educational facilities, and cross-fertilization of caste by intercaste and interclass marriages sponsored as a massive state program. And this solution is calculatedly hidden from the view that by the higher backward groups in a vested interest in the plums of backwardism, but social science research, not judicially impressionism, will alone tell the whole truth, and constant process of objective re-evaluation of progress registered by the underdog categories is essential. Taste on deserving reservation should be degraded into reverse discrimination. Innovations in administrative strategy to help the really untouched, most backward class also emerge from such socio-legal studies and audit exercise if this passionately made. In fact, research conducted by the A.N. Sinha Institute of Social Studies, Patna, has revealed a dual society among horizons, a tiny elite globbing up the benefits and the darker layers slipping distance away from the special concessions. For them, Article 46 and 335 remain a noble romance, as has been called in administrative nihilism, method of so-and-so, so-and-so, the bonanza going to the high horizons. I mention this in the present case because lower division clerks are likely to be drawn from the lowest levels of the horizon community, and promotion prospects being accelerated by withdrawing for a time. Test qualifications for this category may perhaps delve deeper, and equalitarian breakthrough in a hierarchical structure has to use many weapons, as Rule 13 AA perhaps is one. Now, paragraph 26, the whole object of reservation is to see that the backward classes of citizens move forward so that they may march hand in hand with other citizens of India on an equal basis. This will not be possible if only the creamy layer within the class bag all the coveted jobs in the public sector and perpetuate themselves, leaving the rest of the class as backward as they always were. This being the case, it is clear that when a court applies the creamy layer principle to scheduled castes and scheduled tribes, it does not in any manner tinker with the presidential list under Article 341 or 342 of the Constitution of India. The caste or group or subgroup named in the said list continues exactly as before. It is only those persons within that group or subgroup who have come out of untouchability or backwardness by virtue of belonging to the creamy layer who are excluded from the benefit of reservation. Even these persons who are contained within the group or subgroup in the presidential list continues to be within those lists. It is only when it comes to the application of the reservation principle under Article 14 and 16 that the creamy layer within that subgroup is not given the benefit of such reservation. Now, Your Lordship may read paragraph 28. Paragraph 28.
As a whole. Top to bottom, top to bottom. If you leave this
Yeah.
Then Your Lordship may kindly come to paragraph 28. Therefore, when Nagraj applied the creamy layer test to scheduled castes and scheduled tribes in exercise of application of the basic structure test to uphold the constitutional amendments leading to Article 16.4a and 16.4b, it did not in any manner interfere with the Parliament's power under Article 341 or 342. We are therefore clearly of the opinion that this part of the judgment does not need to be revisited, and consequently, there is no need to refer Nagraj to a 7 judges bench. We may add to this, we may also add at this juncture that Nagraj is an unanimous judgment of 5 learned judges of this court, which has held sway since the year 2006. This judgment has been repeatedly followed and applied by a number of judgments of this court. Then, my lord, the several judgments have been given. Then Your Lordship may kindly come to paragraph 30.
Yes.
In fact, the test laid down in Nagraj for judging whether a constitutional amendment violates basic structure have been expressly approved by a 9 judge bench of this court in IR Coelho versus State of Tamil Nadu. The entirety of the decision, far from being clearly erroneous, correctly applies the basic structure doctrine to uphold constitutional amendments on certain conditions which are based upon the equality principle as being part of the basic structure. Thus, we may make it clear that quantifiable data shall be collected by the state on the parameters as stipulated in Nagraj on the inadequacy of representation, which can be tested by the courts. We may further add that the data would be relatable to the cadre concerned. Then Your Lordship may come to paragraph 35. 35. The learned Attorney General also requested us to lay down the proportion of scheduled castes and scheduled tribes to the population of India should be taken to be the test for determining whether they are adequately represented in promotional posts for the purpose of Article 16.4a. He complained that Nagraj ought to have stated this, but has said nothing on this aspect. According to us, Nagraj has wisely left the test for determining adequacy of representation in promotional posts to the states for the simple reason that as the post gets higher, it may be necessary, even if a proportionality test to the population as a whole is taken into account, to reduce the number of scheduled castes and scheduled tribes in promotional posts as one goes upwards. This for the simple reason that efficiency of administration has to be looked at every time promotions are made. As has been pointed out by Justice B.P. Jivan Reddy's judgment in Indra Sahni, there may be certain posts right at the top where reservation is impermissible altogether. For this reason, we make it clear that Article 16(4)A has been couched in a language which would leave it to the states to determine adequate representation depending upon the promotional post that is in question. For this purpose, the contrast of Article 16(4)A and 16(4)B with Article 330 of the Constitution is important. Then, my lord, Article 330 has been quoted. And finally, my lord, paragraph 36 is the conclusion. Thus, we conclude that the judgment in Nagras does not need to be referred to 7 judgments. However, the conclusion in Nagras that the state has to collect quantifiable data showing backwardness of the scheduled caste and the scheduled tribe, being contrary to the 9 judgments in Indra Sahni, is held to be invalid to this time. Now, my lord, this is the, my lord, foundation of my case. And the 2012 amendment that, my lord, I have read, that is not, my lord, in terms of this
2012 amendment, section 5A.
Section 5A, and also, my lord, Section 5, because, my lord, Section 5 provides the 7% for scheduled caste and 5% and 10%. My lord, how this is done, my lord? This is how there has to be quantifiable data on this also.
Sir, this section 5 was enacted when?
Yes, my lord.
When?
That's 1978.
1978. The judgment comes in 2006.
Yes.
Then, at that time, there was any requirement regarding this quantifiable data and this adequate representation on all this theory was there.
No, my lord, these amendments have come after that, my lord. These amendments are of 2012.
In fact, in your petition, you have challenged the validity of Rule 5 only, not 5A.
No, my lord, my prayer is that Rule 5 is the primarily challenge.
Amended provision challenge kiya na, lekin Rule 5 is the main part. Is Rule 5?
My lord, the challenge is, my lord, the set aside and Assam SC and SC Act as amendment in 2012. 2012 amendment.
Amendment and 2012, naming 5. But 5 is the main. We are at all platform. Now, other point is, the interest one may bold that there is a question of quantifiable data SCNS. 5, section 5 relates to SCNS.
I want to respond to your lordship's query. I'm sorry.
Has been clarified in dimension. Quantifiable data will not be applicable. The SCNS will be interest one.
Yes.
My lord, to respond to your lordship's query, my lord, this is a 1978 Act. In fact, my lord, when this act was my lord, enacted in 1978, Article 16(4)A and 4B was not there, and it was only in 1992 that, my lord, in Indra Sahni's case, that was, my lord, this concept came in, my lord, that there cannot be any reservation in promotion. And thereafter, my lord, 2012 amendment came. All these amendments came.
The
These were
2012 amendment is nothing. They have simply said a post-based roster shall be maintained to give effect to the reservation of vacancies. The manner.
My lord, the
They
manner,
have
the
provided
procedure,
the manner and nothing else.
the procedure has been laid down, my lord.
The procedure, the main provision is section 5.
Yes.
5.
No, my lord, my submission is, my lord, if I have understood correctly, that this act was in force since 1978, and what we were doing, that maybe the, my lord, failing. But then, my lord, at that relevant point of time, my lord, these, all these provisions 16(4)(a), 4(b) were not there. The, only, my lord, all these questions came up after Indra Sawhney is that.
At that time, there was no challenge to this section 5.
Yes.
No challenge to the section 5, and ultimately, after introduction of this article 16(4)
And the
B,
petitioners who were before lordship, my lord, they were not in service at that point of time also, my lord.
but this validity of this provision was enacted in the 1978.
No, what the
There
authorities
there
have.
was no requirement of quantifiable data, education, representation, and no such requirement.
Now, my lord, by the 2012 amendment, they are trying to implement it. My submission before lordship is that when you implement it, you have to satisfy the.
Prior to that, this 2012, there was no reservation for reservation and promotion for the SC/ST.
It was there, my.
That was.
It was there. But then, my lord, only the law that came, my lord, 1992, and thereafter, my lord, a series of cases, and eventually these amendments came, 16(4)(a) and 4(b), my lord. These amendments came only in, my lord. Last one.
95, 2000 or 2001.
These amendments came in 2000, 2001.
Acha, Mr. Chaudhary,
My lord.
there are just a couple of questions.
Right.
What is the ground on which you are praying for striking out of these statutory provisions of the statute?
My lord, my.
That there is no data, quantifiable data.
Yes, my lord. There is no quantifiable, two grounds, my lord. There is no quantifiable data as directed by the Honorable Supreme Court, and state has not formed any opinion on the basis of the quantifiable data.
All right. So the questions are as follows. Number one, in the case of Journal Singh also, the Supreme Court has clarified that quantifiable data would not be a relevant factor in case of scheduled caste and scheduled tribe.
Yes.
These section 5 deals with scheduled caste and scheduled tribe. Correct? So there is no question of any quantifiable data, but assuming that there is, at what stage is the quantifiable data required? At the stage of enactment of the statute? If that is so, the statutes were enacted in 1978, as my Lord the Chief Justice has pointed out, and these requirements came in subsequent judgments. So that obviously can't be a ground to strike down a statute which was enacted by a legislative, a competent legislative body. And your case is not that it violates any of the provisions of Part 3 of the Constitution. This is number one. Number two, even if the judgment in Nagraj is to be applied prospectively, even then, you can at best raise this issue if an occasion arises when you can demonstrate that the spirit of Nagraj was required to be followed but has not been followed. What is the question of striking down a statute? And if statute cannot be struck down, then nothing remains in your petition. You can at best raise an issue as and when the exercise of promotion is carried out. If you can point out that it is being carried out in violation of the statutory provisions of the judgments, that could be a ground to interfere, but not perhaps in this case.
I'll try to satisfy your lordship on that. Firstly, my lord, in the other case, connected case, there is already an order of this honorable court that they will not be the exact sentence is not issued the interim order to asylum. It will not be in violation of the directions of the honorable court, honorable Supreme Court. And thereafter also, my lord, promotions are being made till date.
Promotions are
Being made, my lord. Reservation in promotion is being carried out.
that is always there if the court, even if the court has not observed this, certainly they can't act in contravention of the law.
Now, my
laid down
lord,
by the-
now I am showing that, my lord, this is in contravention of the, my lord, the dicta laid down by the honorable Supreme Court. Now, my lord, to the section 5(a), that is for the implementation. And my lord, for this implementation procedure is contrary to what has been laid down by the honorable Supreme Court. In fact, my lord, there is a judgment of this honorable court, a single judgment.
The authority person can. The question was slightly. Highway is basically the rules for implementation.
Remain in dormant state.
Then how will they implement five?
And my lord, there is a judgment of this honorable court by honorable single bench which has happened finally that was not appealed against, delivered by honorable justice Vijay Bhuya, where my lord it has been clearly laid down that my lord, these provisions of reservation in promotion will remain in dormant state till the this requirement laid down by the Supreme Court that has been fulfilled. That my lord. And dormant. That is my lord reported in 2016 volume 1 GLT 710. Paragraph 62 and 63 of the judgment, my lord. Government को प्रोसेस को है Paragraph 47. 47.
No, 63 का ये observation लेकिन repeat तो भी observation में डाला है इसने कहा है कि interest on its observation. 45 only date nothing new. Currency 2018 का ये 2016 का लेकिन interest on it interest on it
Your lordship may also, my lord, peruse paragraph 47
47 of what?
of this judgment, my lord.
But this judgment is based on M. Nagaraj,
Yes.
wherein thereafter this general saying this backwardness this data regarding backwardness that has been done away with.
Paragraph 47, your lordship will see, can be read, my lord. There it has been clearly stated that until this quantifiable data is collected and opinion is formed, my lord, the provisions of the 1978 Act as amended in 2012, so far as provides for reservation and promotion, would remain in a dormant state.
But does Journal Singh not eclipse this judgment prospectively? It's a prospective overruling. Journal Singh says
Journal
it's not
Singh-
required in case of SC/ST.
No, Journal Singh only says, my lord, the requirement of the quantifiable data on backwardness is not required. Other two aspects still remain, my lord. Only with regard to the backwardness of the scheduled caste and scheduled tribe. They are, my lord, backward communities, and therefore that cannot be examined again by collecting quantifiable data. That is
Then quantifiable data on what?
on backwardness. That need not be collected. That is
So quantifiable data is required on what then?
on my lord, the inadequacy of representation and efficiency of administration.
That will be determined by the ceiling. 7%, 10%, 5%.
On the basis of that, my lord, state has to form an opinion whether reservation and promotion is required or not. Data itself is not enough. On the basis of the data,
Then the statute has to be framed every year. In 78, it was required. Today, it may not be required. Tomorrow again, it will be required.
my lord, it
What
can
is the
be-
mechanism then?
no, it can be, my lord, examined from time to time.
Therefore, we posed a question to you
Right.
that as and when the promotion process is initiated, the affected candidates can always approach the court saying that this has not been carried out by following the mandate of these decisions. But if you make a challenge to the statute, and if it doesn't succeed,
No, my lord, in Pavitra, BK Pavitra 2, my lord, the challenge was made. BK Pavitra 1, my lord, the act was, my lord, set aside because this quantifiable data was not collected and opinion was not formed. Subsequently, my lord, the state of Kerala had carried out that. And thereafter, the challenge was made again, and that was not, my lord, entertained by the Honorable Supreme Court.
That data will remain forever or it has to be changed from time to time.
My lord, that is now not specified, but then my act as challenged, my lord, that was the subsequent act, my lord, was not interpreted by this Honorable Supreme Court. Whether that will continue in perpetuity or not, my lord, this is not a question that has been, my lord, considered.
Okay.
I have some more submissions to make, my lord, not much. I'll not take your lordship to the other judgments, my lord, unless in reply I have to say that. But there is a, my lord, judgment of this Honorable Court by a coordinate bench. And my lord, may I please the judgment? Here, my lord, because my lord, the state may come up with this defense. I'll not argue right now, but I am placing the judgment and I'll make submission before lordship, my lord, this judgment of the honorable division, another division bench of this honorable court is per inferium. I'll make the submission if necessary. There, my lord, some certain clauses of a notification that was under challenge. And the honorable division bench, my lord, coordinate bench, has said that, my lord, the quantifiable data can be collected by the departmental promotion committee. Where's my copy?
Which para you are referring to in this judgment, division bench judgment?
My lord. There, my lord, in paragraph 40 and 43, my lord. Those are the findings, paragraph 40 and 43, which in my humble submission is, my lord, not in accordance with the law laid down by the Honorable Supreme Court. Paragraph 40 and 43. In determination of the quantifiable data is, if the determination of the quantifiable data is for adequacy or inadequacy of representation of the reserved category candidate in a given cadre of service in a particular department of the government, we are in agreement with the contention of raised by Mr. So-and-so learned counsel for the respondent, Sri Bhagwan Patter, that it would be more prudent and appropriate to undertake such exercise to Departmental Promotion Committee, in short DPC, itself before embarking upon the promotion process for a given cadre. The same would be prudent in as much as the DPC will have all the data before it as to the cadre strength of the promoted cadre, so and so, so and so. And my lord, paragraph 43. As the three contentions raised by Mr. So and so under senior counsel appearing for the petitioner are answered in the indicated above, meaning thereby that as per the judgment of the Honorable Supreme Court rendered in paragraph 36 of Journal Singh 1, there is no requirement of obtaining quantifiable data as regards backwardness. That is so correct, my lord. And as per the judgment referred to Honorable Supreme Court in paragraph 116 and 126 of the BK Pavitra, quantifiable data on inefficiency in administration across the board in respect of the reserved category candidates cannot be obtained, and further, as the quantifiable data in respect of adequacy or inadequacy of the representation of the reserved category candidates can also be done at the level of DPC in respect of the cadre for which the promotion process had been initiated. We are of the view that the prohibition imposed by paragraph 47 in judgment in Equality Forum 1 that your lordship has just read would have to be understood in the manner indicated. In other words, as there would not be any requirement of obtaining quantifiable data on backwardness and inefficiency in administration, and obtaining the data regarding adequacy or inadequacy of representation can be done at the level of DPC. The prohibition imposed by paragraph 47 in Equality Forum 1 would now no longer hold good, subject to the condition that the DPC, before embarking upon each and every promotion process, undertakes an exercise in to determine the adequacy or inadequacy representation of the reserved category candidate in that particular given cadre where the promotion is sought to be made. Now, my lord, the vital point, the law laid down by the Honorable Supreme Court that the state has to form an opinion on the, my lord, quantifiable data, that has not been, my lord, appreciated by this bench. And this has been left to the, my lord, DPC, and DPC is not a state.
This judgment, we are referring this judgment in your favor, or
This judgment is not in my favor.
it has not been your?
Not in my favor, but I have to place, my lord, all the facts before your lordship. And that's why I say, my lord, this honorable bench has, my lord, did not, my lord, take into consideration the fact that, my lord, forming an opinion by the state. And, my lord, the DPC is a not state which can, my lord, form an opinion by quantify collecting data.
DPC is an instrumentality of state for the purpose of.
It is not a state, my lord. State has to form an opinion. That is the clear dictum of the honorable.
So that data placed before the DPC will be one of the factors which can be taken care of by the state, taken note of by the state.
So DPC itself will, my lord, decide on the basis of that quantifiable.
No, Mr. Chaudhary, the query was very straightforward and simple.
My lord.
First of all, the grounds for challenging a statute are very well laid down, well established, either on the ground of legislative competence or violation of Part 3 of the Constitution. None of these are your case. None of these grounds are the grounds taken in the writ petition. The ground you have taken is quantifiable data which relates to implementation of the provisions.
Yes.
So that will depend on facts of each case.
Yes.
what was the reality in 1978 need not be the reality in 2024. So as and when the act is implemented, if any affected party in his or her own capacity is aggrieved, he can or she can always approach the court raising these issues. Why should a kind of a PIL be, it is a PIL kind of sorts. Why should it be entertained that too when there is no ground really to strike down the statute? That's the question we are
My
asking
lord,
you.
yes, I understand your lordship's query, my lord.
And
My
that
answer is
too
very
when the learned single judge's observation in para 47 has been overruled by the division bench. So that would have a binding effect on this court.
No, my lord, provided, my lord, I'll try to satisfy your lordship, my lord. This judgment of the coordinate bench is also, my lord, per inquiry the Honorable Supreme Court judgment. I can certainly argue on that, my lord. And my lord, my ground is very simple, my lord, very simple. That Honorable Supreme Court has said that for implementing, for giving reservation and promotion, you have to have the quantifiable data on two aspects. And based on that, the state has to form an opinion. And without that, you cannot do it. On that ground, I'm challenging the Mala 2012 amendment, which has provided for the procedure. And in this case of the coordinated benches judgment, Mala, that was regarding one clause of a Mala of a OM, where also Mala the procedures were thought to be laid down. No act was challenged. Act has been challenged in these two cases only. Mala. There are many other cases. The office memorandums were Mala checked. In fact, random numbers. My lord, in fact, I have got another submission, my lord. Because so far as section 5 is concerned, that 7%, 5%, 10%, my lord, this ought to have been revisited after the my lord Nagraj's judgment.
Is this not an issue to be raised in the assembly rather than the court? Before
SLP. My lord, what else, my lord, improve your lordship is that, my lord. In the event, my lord, your lordship is satisfied, the coordinate bench judgment is, my lord, your lordship will not agree, then, my lord. No, there are possibilities.
I'm not expressing any opinion on behalf of
my
the
lord,
bench. These are just some queries to understand.
True, my lord.
With more clarity, what are the various facets of this litigation? That's why.
That's why, my lord, the other judgment I have placed before lordship, my lord, because I have to place everything. It's not that, my lord, I conceal something and try to get some order from this. But then, my lord, your lordship may take a contrary view, refer it to a larger bench, or your lordship may say that that is binding. And although, my lord, the act was not under challenge in any of the cases. Therefore, your lordship may ignore that judgment, or your lordship may hold that this is para incorum the Honorable Supreme Court judgment. These are all possibilities, my lord, I am submitting. I'll, my lord, not take much time. If reply is required, my lord, I'll give. My learned friend has got another case, my lord.
My lord, I'm in item number 8.
My lord, basically, I adopt the argument advanced by my senior man. Only thing is, my lord, I want to point out some paragraph in M. Nagaraj. My lord, may kindly come to paragraph 121 of M. Nagaraj.
Yes.
My lord, this is the conclusion part of the judgment by the 5 judges bench, my lord. 121 reads as the impugned constitutional amendment by which Article 16(4)(a) and 16(4)(b) has been inserted from Article 16(4). They do not alter the structure of 16(4). They retain the controlling factors of compelling reasons, namely backwardness, inadequacy of representations enables the state to provide for reservation, keeping in mind the overall efficiency of the state administration under Article 335. My lord, what the apex court is saying, my lord, by this, my lord, the apex court identified the compelling reasons to bring an enactment providing reservation in promotion, my lord. That enactment either way by legislation or by the OM that can be brought. But before bringing that enactment or that provision, my lord, these compelling reasons that has to be satisfied. And the judgment of M. Nagaraj was beautifully explained by UP Power Corporation. I want to rely on that, my lord. Where UP Power Corporation 2012-7 SSC phase 1. My lord,
Yes.
your lordship has made a query that when it has to be opined by the state. My lord, that is precondition. This UP Power Corporation, they have stated categorically, this is the precondition for bringing a legislation for providing reservation in
Just a
promotion.
minute, any law on this point, that any enactment which is in operation prior to the Nagaraj case, whether validity of that enactment has been challenged, that before there was no adequacy of the quantifiable data, no the data regarding inadequacy in representation, and on the ground, any such law has been struck down by any court.
My lord, I will give reply to that, my lord.
Yes.
My lord, before that, my lord, I am placing this judgment, my lord, and thereafter I will give you give the reply, my lord.
Yeah.
Paragraph 80, my lord. 80.
Yes.
This is the conclusion part of the M. Nagaraj judgment, my lord. It's a
Paragraph.
paragraph 80, my lord. May I read, my lord?
Yeah.
In the conclusion portion in para 123 and 124, it has been ruled thus, M. Nagaraj case 123. However, in this case, as stated above, the main issue concerned extent of reservation in this regard. The state concern will have to show in each case the existence of compelling reasons, namely backwardness, inadequacy of representation, and overall administrative efficiency, before making provision for reservation. My lord, before making provision for reservation, that means it's precondition, prerequisite, man. As stated above, the impugned provision is an enabling provision. The state is not bound to make reservation for SC/STs in matters of promotion. However, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing the backwardness of the class and inadequacy of representation of that class in public employment in addition to compliance with Article 335. It is made clear that even if the state has compelling reasons, these three were the compelling reasons, as stated above, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling limit of 50% or obliterate the creamy layer or extend the reservation indefinitely. Para 124. Subject to the above, we uphold the constitutional validity of the Constitution 77 Amendment Act 1995, the Constitution 81st Amendment Act 2000, the Constitution 82nd Amendment Act 2000, and the Constitution 85th Amendment Act 2001. Now, para 81, my lord. From the aforesaid decision, M. Nagra's case, and the paragraphs we have quoted herein above, the following principles can be carved out. These 8 principles were laid down, 10 principles were laid down by this honorable court by interpreting the judgment of M. Nagraj. Clause 1, vesting of the power by enabling provision may be constitutionally valid, and yet exercise of power by the state in a given case may be arbitrary, particularly if the state fails to identify and measure the backwardness and inadequacy, keeping in mind the efficiency of service as required under Article 335. 2. 16(4), which protects the interest of certain regions, certain sections of the society, has to be balanced against Article 16(1), which protects the interest of every citizen of the entire society. They should be harmonized because they are restatements of the principle of quality under Article 14. Each clause 3, each post gets marked for the particular category of the candidates to be appointed against it, and any subsequent vacancy has to be filled up by that category candidate. Clause 4, the appropriate government has to apply the cadre strength as a unit in the operation of the roster in order to ascertain whether a given class group is adequately represented in the service. The cadre strength as a unit also ensures that upper ceiling limit of 50% is not violated. Further, roster has to be post-specific and not vacancy-based. Clause 5, the state has to form its opinion on the quantifiable data regarding education of representation. Clause 4A of Article 16 is enabling provision. It gives freedom to the state to provide for reservation in the matters of promotion. Clause 4A, Article 16 applies only to SC/ST. The said clause is carved out of Article 16(4)(a). Therefore, Clause 4A will be governed by 2 compelling reasons: backwardness and inadequacy of representation, as mentioned in Article 16(4). If the said 2 reasons do not exist, then the enabling provision cannot be enforced. Clause 6, madam. If the ceiling limit on the carryover of unfulfilled vacancies is removed, the other alternative time factor comes in, and in that event, the time scale has to be imposed in the interest of efficiency in administration as mandated by Article 335. If the time scale is not kept, then post will continue to remain vacant for years, which would be detrimental to the administration. Therefore, in each case, the appropriate government will now have to introduce deputation duration depending upon the fact situation. 7, if the appropriate government enacts a law for providing for reservation without keeping in mind the parameters in Article 16(4) and Article 335, when this court will certainly set aside and strike down such legislation. My lord, here, my lord, clause 7 is very clear, my lord. If the appropriate government enacts a law without fulfilling the requirements under 16(4) and Article 335, it will be struck down. Clause 8, my lord. The constitutional limitation under Article 335 is relaxed and not obliterated. As stated above, it is it be it reservation or evaluation, excessiveness in either would result in violation of the constitutional mandate. This exercise, however, will depend on the facts of each case. Clause 9, the concept of efficiency, backwardness, and inadequacy of representation are required to be identified and measured. That exercise depends on the availability of the data. That exercise depends on numerous factors. It is for this reason that the enabling provisions are required to be made because each competing claim seeks to achieve certain goals. How best one should optimize these conflicting claims can only be done by the administration in the context of local prevailing condition in public employment. Article 16, next, my lord, Article 16(4) therefore creates a field which enables a state to provide for reservation provided there exists backwardness of a class and inadequacy of representation in employment. These are compelling reasons. They do not exist in Article 16(1). It is only when these reasons are satisfied that a state gets a power to provide reservation in the matter of employment. Now, my lord may come to paragraph 86, my lord. Yes. Paragraph 86 read as, we are of the firm view that a fresh exercise in the light of the judgment of the Constitution Bench in M. Nagras is a categorical imperative. The stand that constitutional amendments have facilitated the reservation in promotion with consequential seniority have given the stamp of approval of the Act and the rules cannot withstand close scrutiny in as much as the Constitution Bench has clearly opined Article 16(4)(a) and 16(4)(b) are enabling provisions, and the state can make provisions for the same on certain basis of foundation. The condition precedent, the word used by the Apex Court, this is the condition precedent have not been satisfied. So, my lord, before bringing such legislation, or by way of enactment or by way of whim, the condition precedent is that, my lord, the state has to collect the quantifiable data before bringing such enactment, my lord. No exercise has been taken. I will continue, my lord. The condition precedent have not been satisfied. No exercise has been undertaken. What has been argued with vehemence is that it is not necessary as the concept of reservation in promotion was already in vogue. We are unable to accept the said submission, for when the provisions of the Constitution are treated valid with certain conditions of riders, it becomes incumbent on the part of the state to appreciate and apply the test so that its amendments can be tested and withstand the scrutiny of on parameters laid down therein. Next, 87, my lord. In the ultimate analysis, we conclude and hold that Section 3(7) of the 1994 Act and the Rule 8A, my lord, 1994 Act and Rule 8A of the 1994 Act, my lord, and Rule 8A of the 2007 rule are ultra virus, as they run counter to the dictum in M. Nagras.
Yes.
That's referred, my lord, 1994 Act, my lord. That was citizen. Any promotion that has been given to the on the dictum of Indra Sahani and without the aid of assistance of Section 3(7) and Rule 8A shall remain undisturbed. My lord, my lord, I believe, my lord, I get the reply of your lordship query. That's a 1978 Act. This is 1994 Act before amendment of 85th Amendment and before my lord, Nagraj judgment. Now, I want to place journal thing that is 2018-10 SCC 396, my lord. Only few paragraphs, my lord.
Yes.
26, 27, my learned friend has already placed, my lord. Only thing, my lord, in journal thing, my lord, it was categorically stated, my lord, creamy layer has to be excluded. Like in journal thing, they gave one rider, that is backwardness, and they put another rider, that is creamy layer, in between the schedule caste and schedule tribe. My lord, why this judgment, my lord? Because some of the Attorney General and other petitioners, they challenge that M. Nagras is not a good law. While 5 judges benches, they, while considering the argument, my lord, they observed that para 27. Para 27, we do not think it necessary to go into whether Parliament may or may not exclude the creamy layer from the presidential list contained under Article 341, 342. Even on the assumption that Article 341 and 342 empower Parliament to exclude the creamy layer from the groups of or subgroups contained within this list, it is clear that constitutional courts applying Article 14 and 16 of the Constitution to exclude the creamy layer cannot be said to be thwarted in this exercise by the fact that persons stated to be within a particular group or subgroup of in the presidential list may be kept out by Parliament on application of the creamy layer principle. One of the most important principles that has been frequently applied in constitutional law is the doctrine of harmonious interpretation. When Articles 14 and 16 are harmoniously interpreted along with other Article 341 and 342, it is clear that Parliament will have complete freedom to exclude or include persons from the presidential list based on relevant factors. Similarly, constitutional courts, when applying the principle of reservation, will be well within their jurisdiction to exclude the creamy layer from such group or subgroups when applying the principles of equality under Article 14 and 16 of the Constitution of India. We do not agree with so-and-so. Paragraph 28. We therefore, when Nagraj applied the creamy layer test to scheduled caste and scheduled tribes in exercise of application on the basic structure test to uphold the constitutional amendments leading to Article 16(4)(a) and 16(4)(b), it did not in any manner interfere with Parliament's power under Article 341 or 342. We are therefore clearly of the opinion that this part of the judgment does not need to revisit it, and consequently there is no need to refer Nagraj to a 7-judge bench. We may also add it at this juncture that Nagraj is an unanimous judgment of 5 learned judges of this court, which has held sway since the year 2006. The judgment has been repeatedly followed and applied by a number of judgments of this court, namely, these are the citation, my lord. Paragraph 30 is very important, my lord, wherein the apex court held that, yes, we have to collect the quantifiable data. Paragraph 30, in fact,
They already referred.
my lord,
Mr. Chaudhary has already.
yes, my lord, only thing, the last third paragraph, third sentence, we may make it clear that quantifiable data shall be collected by the state on the parameters as stipulated in Nagraj on the inadequacy of representation, which can be tested by the courts. We may further add that data would be relatable to the cadre concern. My lord, I'd like to place 2023 SCC phase 1, Mukesh Kumar. Here, paragraph 18 is relevant, my lord. I am placing paragraph 18, my lord. Here, my lord, in paragraph 18, the apex court held that it's a prerequisite. Collection of quantifiable data is prerequisite. I'm reading, my lord. The direction that was issued to the state government to collect quantifiable data pertaining to the adequacy or inadequacy of representation of persons belong to scheduled castes and scheduled tribes in government services is the subject matter of challenge in some appeal before us. In view of the law laid down by this court, there is no doubt that the state government is not bound to make reservation. There is no fundamental right which inheres in an individual to claim reservation in promotion. My lord, that is not a fundamental right, my lord. No mandamus can be issued by the court directing the state government to provide reservation. It is abundantly clear that from the judgment of this court in Indra Sahani, Ajit Singh, M. Nagraj, Jarnail Singh, and that Article 16.4 and 16.4a are enabling provisions, and the collection of quantifiable data showing inadequacy of representation of scheduled castes and scheduled tribes in public service is a sine qua non for providing
Yes. Yes.
of representation of scheduled castes and scheduled tribes in public service is a sine qua non for providing reservation in promotion. The data to be collected by the state government is only to justify reservation to be made in the matter of appointment or promotion to public posts according to Article 16.4 and 16.4a of the Constitution. As such, the collection of data regarding the inadequate representation of members of scheduled castes and scheduled tribes, as noted above, is a prerequisite. The apex court clearly said that is a prerequisite for providing reservation and is not required when the state government decided not to provide reservation. So before bringing the enactment, it is prerequisite, my lord. That is my humble submission. It's prerequisite. That has to be satisfied, my lord. Then only they can bring, the state can bring reservation in promotion. My lord, next citation, my lord. Prabhakar Malik, 2020-15 SCC 297.
At 2.
My lord.
Today, since matter is already going on, hearing matter is going on, we'll take up this matter on any other date.
Tomorrow, Lordship.
Tomorrow,
Not tomorrow, my lord.
Friday,
Friday.
Lordship.
Friday.
Lordship.
You bring the record.
Yes, Lord.
Record has been received, Dr. P.
Now, receipt you keep record with you. Place it on.
Lordship. Highly obliged.
Deep level.
So 6th Friday. Yes.
My lord, next citation I am relying 2023 SCC, page 1. Mukesh Kumar,
That you have read on.
my my lord. My
Particularly
lord, I am
30,
relying paragraph 20, my lord,
Paragraph
20.
of this Mukesh Kumar.
Prabhakar Malik ko kulun. Okay, my lord. Prabhakar Malik में. Yeah. Prabhakar Malik. Referring to Mukesh Kumar or Prabhakar?
You are referring to which judgment?
2015 SCC
15 SSC.
297. I'm relying paragraph 20, my lord.
Yes, yes. Sir.
मुझे guilty फॉर्म क्यों लगे?
What time did I put in?
Hmm? Huh? बेसी बड़ा फॉर्म है. मैं तो करूँ.
Para 15.
Paragraph 20, my lord, 20.
Yes.
Here, my lord, all the earlier judgment passed by the apex court were discussed in this judgment, my lord. Paragraph 20. Further, BK Pavitra versus Union of India, this court has held that determination of inadequacy of representation, backwardness, and overall efficiency is mandatory for exercising power under Article 16(4)(a). It is further held in the said case that mere fact that there is no proportionate representation in promotional posts for reserve category candidates by itself is not sufficient to extend the benefit of confidential seniority to promotees who are anywhere otherwise junior. It is held that in absence of such mandatory exercise by the state, the catch-up rule fully applies. Para 21. In Journal Singh, while answering the reference, a constitution bench of this court has held that the judgment of M. Nagraj need not be revisited by referring to a 7-judge bench. At the same time, it held that the conclusion in M. Nagraj that the state has to collect quantifiable data showing backwardness of scheduled castes and scheduled tribes is held to be invalid on the ground that the same runs contrary to the 9-judge benches of this court in Indra Sahani versus Union of India. It is also held in the said judgment that Article 16(4)(a) has been couched in language which would leave it to the state to determine adequate representation depending upon the promotional post in question. 22. Further, in BK Pavitra, this court, while considering the validity of Karnataka determination of seniority of the government servants promoted to the basis of reservation to the post of civil services of the State Act 2002, has upheld the Act on the ground that the same was enacted by making study regarding inadequacy of representation and overall administrative efficiency. My lord. Yes. My lord, up to 2020, my lord, the apex court held that, yes, these are the judgment holding the field, my lord, and the state has to, the state has to collect quantifiable data before enactment, either way of legislation or by way of notification. They can do it, but before enforcing that, my lord, it's a prerequisite, it's a precondition, my lord. My lord, I'm facing this. BK Pavitra to that. 2019-16 SCC, page 129. Yes, my lord. I'm relying paragraph 153. Only one paragraph I'm relying, my lord. Here, my lord, what happened? In BK Pavitra 1, the act was, Reservation Act was challenged and it was set aside by the apex court. Then, my lord, the state has taken care of the rider and exercise to collect the quantifiable data. Accordingly, they passed the enactment. That was challenged. Now, my lord, what does apex court held, my lord? Paragraph 153. For the above reasons, we have come to the conclusion that the challenge to the constitutional validity of the Reservation Act 2018 is lacking in substance. Following the decision BK Pavitra 1, the state government duly carried out the exercise of collating and analyzing data on the compelling factors adverted to by the Constitution bench in Nagraj. The Reservation Act 2018 has cured the deficiency which was noticed by BK Pavitra 1 in respect of Reservation Act 2002. The Reservation Act 2018 does not amount to assumption of judicial power by the state legislature. It is Nagraj and Journal compliant. This is the finding of the apex court. It's compliant. This enactment was brought into force in compliance with the Nagraj and Journals. My lord, what is important, my lord, that yes, if you want to give the enactment, the power, if you want to enforce it, you have to comply with the minimum requirement. The riders that given by the Nagraj upheld by Journal Singh. My lord, here, my lord, kindly consider the yes. Here, my lord, kindly consider the facts and my lord, facts and circumstances, my lord. Yes. And for that, my lord, I am placing once again Equality Forum Judgment 2016 1 GLT 710. Yeah. Here, my lord, the scenario in Assam, after passing the interim order in this petition, my lord, uh, after passing that, state has exercised the power to collect the quantifiable data by one-man commission. My lord, may kindly come to paragraph 7, my lord. Yes, paragraph 7. Ultimately, the one-man commission submitted its report dated 10/3 to 2014 to the government of Assam in WPT and BC department. The one-man commission concluded that SC/ST communities in Assam are still backward. Their representation in public employment is not adequate, and overall efficiency in public administration has not been affected by providing for reservation in promotion to such communities. Therefore, the commission recommended that reservation in promotion in favor of the members of SC/ST should continue till such time the state government is satisfied that such groups had advanced to such level at par with the more advanced groups. My lord, what happened, my lord? In this judgment, these findings of one-man commission report was set aside. The state knows fully well that we have to collect the quantifiable data before enforcing the law. But after setting aside the one-man commission report, the state has not exercised once again, madam. By way of whim or anything, my lord, they are trying to bring some, trying to make some puzzle and all, but they fail to collect the quantifiable data. Yes, they knows it. There is no escape from collecting the quantifiable data. That's why they have appointed one-man commission, and that's why one-man commission has given report after collecting some faulty quantifiable data, which was set aside by the single bench. And against this matter, neither the state nor any other party has preferred any appeal. This one-man commission's report and the collection of quantifiable data, as of today, my lord, it's settled position, my lord. My lord, one thing I would like to place, my lord. Uh, 16(4)(a) of the Constitution. Yes, my lord, why I am placing, my lord, is only for the reason, my lord, opinion of the state. Nothing in the article shall prevent the state from making any provision for reservation in matters of promotion which with consequential seniority to any class or classes of post in the services under the state in favor of scheduled castes and the scheduled tribes, which in the opinion of the state. So while amending Article 4A, the legislature emphasizes, my lord, opinion of the state. My lord, the riders given by the apex court in Nagraj judgment is nothing but this, my lord, opinion of the apex court interpreted this opinion of the state, and they put the 3 riders. Out of 3, 1 has gone, my lord. The remaining 2 are there, my lord, and that has to be followed, my lord. My lord, now I'd like to place only one thing from Indra Sahani, my lord. 1992 Supplement 3 SCC, page 217. This judgment is famous judgment of Mondal Commission, my lord. I am placing only one paragraph, my lord. That is page 7766, para 1859, my lord.
766.
766. Yes. My lord, what was challenged before the apex court was 16.4 and 16.1. Yes, 15.4 and all, and some other, my lord. My lord, now, my lord, I am placing 859. Here, the apex court summarizes the findings.
Yes.
My lord, firstly, I am placing 767. We may summarize our answers to the various questions dealt with the answered herein above. My lord, kindly come to D. D of 3 at page 767.
Yes.
Here, my lord, the apex court discussed that creamier can be and must be excluded. Now, kindly come to next page 768. 768 article summarize clause number 7.
Yes.
Article 16.4 does not permit provision for reservation in the matter of promotion. My lord, this judgment came into force, my lord, in 1992, my lord. 1992. Admittedly, 78 Act was under 16.4, my lord. That goes, man. Goes this judgment, my lord. 16.4. Apex court held that 16.4 does not permit provision for reservation in the matter of promotion.
Yes. Yes.
My lord, that is my humble submission before your lordship that the state has to collect quantifiable data before giving effect to the reservation information. My lord, the constitutional history regarding 16.4 and 16.4A and all the judgment, I am giving a synopsis, my lord. For,
All the judgments are what?
my lord, that will do, my lord. Oblige, my lord.
Yes.
Yes. And if your lordship takes up the first petition, that is WPC 4034 of 2013,
That is Equality Forum.
Equality Forum. It's a petition filed by the society, my lord.
Yes.
And lordship, I'll draw your lordship's attention to page 21. That is the prayer portion of the, my lord, writ petition.
Yes.
Lordship will kindly see the first prayer is to issue a writ in the nature of certiorari for setting aside and quashing the impugned Assam Scheduled Caste and Scheduled Tribes reservation of vacancies in service and post, Amendment Act 2012. And the second is Section 5 of the Parent Act. Now, Section 5 provides for the percentage of reservation in respect of various categories of the reserved category people. So far as the first prayer is concerned, my lord, this is basically introduction by the amendment. The post-based roster concept was introduced with the Assam Act of 1978. And this post-based roster is a, my lord, outcome of R.K. Sabarwal judgment. My lord, I'll take your lordships to various paragraphs of the petition. And the prayer portion is in respect of both the petitions are same. Their basic challenge is the amendment to the Act of 1978, whereby the dicta of R.K. Sabarwal, whereby the Supreme Court said, my lord, that it will be not vacancy based, but will be post-based roster. That is their prime challenge in both the writ petitions. However, my first submission will be the amendment to the 1978 Act by this 2012 amendment was introduced after the judgment passed by R.K. Sabarwal. Now, I'll take your lordship to that judgment, my lord, to show that why that post-based roster under what circumstances and what has been laid down in the R.K. Sabarwal judgment. Unless the petitioners succeed in showing that the judgment passed by the Supreme Court in R.K. Sabarwal is wrong, the first prayer cannot be granted, my lord. Because the amendment itself is the implementation of the judgment passed by the Supreme Court in R.K. Sabarwal. So far as the second pair is concerned, my lord, I shall make two different submissions in respect of the two petitions. I'm just giving the outline of what I'll be arguing, my lord. Yes. So far as the second relief sought in both the petitions is concerned, my lord, although they are challenging section 5, so far as the first petition, that is WPC number 4034 is concerned, as my learned friend Mr. Poisho, my lord, in the second case has pointed out, this writ petition was filed in 2013. My lord, primarily on the ground, although that quantifiable data as directed by the Supreme Court in Nagaraja was not collected for providing for reservation information. But my lord, during the pendency of this writ petition, quantifiable data was collected through a one-man commission that was put to challenge. In fact, after the report was submitted by the one-man commission, it was placed before the cabinet. Cabinet passed the recommendation of the one-man commission. Thereafter, a notification was issued in 2014, providing for reservation promotion. That all those notifications, including the notification of 2014, which provided for reservation promotion in posts, was put to challenge in the first writ petition filed by, in the first round of litigation filed by the Equality Forum. In that case, my lord, all Supreme Court, I'm sorry, my lord, this honorable court has gone into the question of validity of reservation in promotion policy of the government and held that the act will remain dormant till the state collects quantifiable data for the purpose of implementation of the act. Thereafter, my lord, in 2016, a fresh memorandum was issued by the government providing for reservation in promotion, along with other connected matters like, my lord, consequential seniority and catch-up theory, those things where these are incidental to the reservation in promotion. Because if there is no reservation in promotion, there is no question of catch-up theory or consequential seniority. Only when there is a reservation in promotion, these theories will come. We are not very much concerned with those ancillary theories. We are concerned with the reservation in promotion. Fact remains, admittedly, in 2016, on 3rd of August 2016, the state government published a notification saying that we have reservation in promotion. That was again put to challenge by the Equality Forum, same society, man. The writ petition was dismissed so far as their contention, challenging the validity of that OM is concerned. Then the writ appeal was preferred by them, and in the writ appeal, some modifications were made in respect of the ancillary matters. But in so far as reservation in promotion is concerned, the judgment passed by the single judge upholding the policy of reservation in promotion was not disturbed. In that view of the matter, my lord, my submission will be so far as the second pair is concerned, my lord, in this case, and in the first writ petition, possibly it has become redundant after this subsequently some developments have taken place, and the division bench passed an order upholding the policy of reservation. They are challenging section 5, basically saying that we are challenging the policy of reservation in promotion. And if your lordship, my lord, if I can take your lordship to the various paragraphs of the petition, although they have given the history of the development of the law of reservation, starting from Indra Sawhney judgment in 1995, my lord, they are basically concerned because this writ petition was filed after the amendment of 2012. This writ petition was basically filed challenging the post-based roster. And in fact, my lord, in the second writ petition, which my learned friend Mr. Poisho has argued, I'll take your lordship, they were basically through representation they have filed. Their grievance was that while working out the roster, post-based roster, in terms of the judgment passed by the Supreme Court and consequent upon that amendment was made in the state, you have exceeded the limit. Their grievance is about excess of reservation and not the post-based roster as such.
They have not argued that.
Well, they have not argued. I am talking about the petition. This is the pleading in the petition. They cannot travel beyond the petition now after 10 years. They are traveling beyond the petition, my lord. I will show you, lordship, man. Just for the sake of reference, immediately, as your lordship has said, my lord, they have no argument there. Lordship, may kindly take this WPC 2752.
2757.
2752, my lord.
57.
2752. Second read petition, my lord. The second case.
Yeah, Shakil Chandru.
कितना है? 2752 है?
Yes, 2752.
Yes, ma'am. Lordship may kindly turn to page 20, para 13. Para 13 at page 20, my lord. May I read out, my lord? That the petitioner begs to state that the cadre strength of Deputy Commissioner of Taxes is 15. And the reservation of percentage under the different category as per the post-based roster of the cadre of Deputy Commissioner of Taxes made in pursuant to the Assam Scheduled Caste and Scheduled Tribe Reservation of Vacancies in Services and Posts Amendment Act 2012 are as shown below. Now they have given 7%, 10%, 5%. Hence, on the basis of the community-based reservation, the number of reservation as per prescribed percentage for the category of Deputy Commissioner of Taxes with 15 posts are as follows. However, next paragraph, my lord. In the post-based roster of cadre of Deputy Commissioner of Taxes, the following 4 posts have been reserved as shown below. Now, next paragraph, my lord. It is apparent from the above that as per law and spirit of reservation, on the basis of community, an excess reservation of 1 post each to STP and STH community have been awarded. The reservation of 4 posts within the cadre of 15 posts raises the percentage of reservation from 22% to 26.67%, which is absolutely unconstitutional. So, my lord, their grievance is not about the implementation of the post-based roster concept introduced by the Honorable Supreme Court in R.K. Sabharwal's judgment and implemented by this state, my lord, by making an amendment to the 1978 Act. Not only that, my lord, lordship may kindly turn to their this representation. This is a petition by an individual. He submitted 2 representations after that he filed this petition. Lordship may kindly turn to his representation at page 43 first, my lord.
Yes.
Page 43 is the reservation, my lord. Sorry, representation. Then your lordship, he has given all the difficulties he has faced because of the excessive reservation. And then lordship may kindly turn to his prayer portion at page. It should be 90, my lord, not properly.
90.
I'm sorry, my lord, it should be 40, 50, I think. Pagination is somehow not very clear in my petition. 42, 48. And the last page of this representation, my lord. In view of the contentions raised herein above, and the law laid down in the matter of Honorable Supreme Court of India in the case of R.S. Garg Supra, and the prescription laid down in the case of R.K. Sabharwal, we request you to take necessary remedial measures so that there is no increase in the percentage of reservation as mandated under the provisions of Assam Scheduled Caste and Scheduled Tribe Reservation of Vacancies in Services and Posts Act 1978. Same is the, my lord, representation subsequently made at page 50, my lord. At page 58, he has asked for the relief. Page 58, my lord. 3 persons submitted this representation. In view of the contentions raised herein above, and the law laid down in the matter of Honorable Supreme Court of India in the case of R.S. Garg, and prescription laid down in R.K. Sabharwal, we request you to take necessary remedial measures so that there is no increase in the percentage of reservation. So they are not against the amendment as such. They are his grievance, the writ petitioner's grievance. Yes, my lord. There are 2 petitions. I'm sorry, my lord. There are 2 petitions. the petitioner's grievance is the excessive reservation which was done by issuing a notification for the purpose of implementing the post-based roster. The roster that was published according to them has exceeded the limit of reservation. So in essence, my lord, this writ petition is not a writ petition challenging the provisions of the act. And your lordship will find they have nowhere indicated how he is agreed by the act itself. And he has not said anywhere that it is the act is passed by a my lord, the state legislature which is incompetent, or it is violative of any of the provisions of the Part 3 of the Constitution of India.
Yes.
Now I'll take your lordship, my lord, for so far as first payer is concerned in both the cases, the challenge is to the amendment of 2000.
Mr. Counsel, in this section 5, you have provided 7% and 10%.
My lord.
After that 2016 excise, what is the percentage of reservation?
Same, my lord.
Same.
Same. In 2016, my lord, OM, somehow this is not there. That is why, my lord, in 10 years, so many developments have taken place, single bench, then division bench. In 2016, my lord, we have said that we have reviewed the matter and we are providing for reservation promotion, apart from other ancillary matters as to whether it should be catch-up theory after the reservation is made for the
70, 70. But in you challenge that there is a mismatch between the data. It's the second limb of challenge, which is in a way self. We should validate the entire mismatch. 60 million है ना Mr. Majumdar, 2016 OM has been upheld by the court.
yes.
Where is the judgment?
My lord, that is reported in Bhagwan Patar. My lord, this is reported judgment. My lord, 2022 volume 3 GLT 520. I have given a book list, my lord, that should be available. 2022 volume 3 GLT 520.
Where is that?
I have got a copy. I have given a book list in the morning itself.
Compilation. Your compilation is this one. Yes. Yes. The compilation page.
Page 2 है.
121. 121.
GLT and GLT.
This judgment was
Page 520. Page 520. And the book is here, lordship. May good refer the books. Journal.
What has happened to the writ appeal against this judgment?
Writ appeal is upheld.
What is that order?
This is single bench.
This is a single bench. Division bench order.
Division bench also is reported, my lord.
I have already given the copies.
This is.
My lord, division
bench has overruled the 2015 judgment of the learned single judge.
So division bench is this IV Gohai Dasgupta. That is
writ appeal, my lord. Yes.
It has overruled that equality judgment, which has been the anchor sheet of the argument of my learned senior. That has been considered to be a backlash because it's violation of the journal 1.
This is you are referring to 2023 GLT 521. Yes. This is what the judgment.
My lord, 2022 volume 3 GLT page 520.
22. It's not 2020. 2020.
And the division bench is 2023 4 GLT
864.
That is, this Ivy.
Ivy
Gohar,
wine, yes.
Das Gupta.
Yes, it
My
will upheld the Bhagwan Patta single judge's order and overrule the earlier equality forum judgment of the learned single.
In fact, my lord, this division bench judgment is a common judgment in 2-3 appeals. One writ appeal was filed by the equality forum also against the single judge judgment. If your lordship has taken the single bench judgment by Bhagwan Patar, I will refer to the paragraph.
Yeah, that is here. Yeah.
2022 volume 3 GLT. तुम्हें लिखा ना copy? 120. Bhagwan Patar. If your lordship has the
Justice Chaudhary's judgment.
yes, my lord.
Yes.
Honorable Justice A.D. Chaudhary, my lord. Lordship may kindly come to paragraph 1A. Summary of the litigation.
Yes.
These two writ petitions, WPC number 5026 of 2016 and WPC 5005 of 2016, are taken up together for disposal. By way of both these writ petitions, a challenge is made to the office memorandum dated 3/8/2016. The writ petition in WPC 5005/2016 challenges the clause 3 and 4 of the said office memorandum dated so and so, whereas the petitioner in WPC 5026 of 2016 challenges the entire office memorandum. This writ petition was filed by the equality forum.
Yes.
Now, if I take a can take a lordship to the my lord findings. My lord, the para 7 Roman 5, my lord, 7-5.
Page.
In the compilation page.
Page 116.
One.
Lordship has got my lord.
Yes.
This is para 7 Roman 5. The determination of cadre as a unit for collection of quantifiable data as laid down in OM dated 3/8/2016 conforms to the mandate of Jarnal Singh and M. Nagaraja, and therefore the same is upheld. So this was upheld by the honorable single judge. Then a writ appeal was preferred, which is my lord, reported in 2023 4 GLT 864. In the same my lord, compilation, this page 160, if your lordship, for a moment, my lord. 160.
Yes.
Roman 8, my lord.
8.
Roman 8, lord, has your lordship got. Given the dictum in Jarnal Singh Supra, the judgment made in the Equality Forum 1 relating to collection of data to determine backwardness has become redundant. But this is to some extent not relevant here. This being the position, my lord, the almost single judge's judgment was put to challenge in writ appeal 239 by the Equality Forum, my lord. And then the judgment reported in 2023, volume 4 GLT, page 864. It was a compilation.
Yes.
আমি প্রপোজাল দিয়া আছে রিপোর্টেড নহয়
আচ্ছা
Yes.
Yes. Here your lordship will find and just
Yes.
para 46, man. Some modifications were made in respect of the judgment passed by one single judge, but the others remain.
para 46. Upon the issues being raised in the present appeals having been decided in the manner indicated above, it is further provided that the decisions rendered in the present judgment in writ appeal number so and so and so and so and so and so would prevail over all such provisions of the learned single judge in judgment dated so and so in WBC number so and so, but in respect of any other provisions which may not be contrary or inconsistent with the provisions of this judgment, the same may prevail. But with a further clarification that if any such provisions of the judgment of the learned single judge is in conflict or contradictory to any of the provisions in the present judgment, such provisions and judgment of the learned single judge stands modified accordingly. And what happened in this case, my lord? My lord, your lordships are aware that, my lord, what has happened in this case, there are 2-3 appeals. One writ appeal was in respect of the consequential seniority after the, my lord, reserve category persons get accelerated promotion. The issue was whether they will be entitled to accelerated seniority also or not. The office memorandum of 2016 provided that it is the catch-up theory which will prevail and not the consequential seniority. Almost single judge has upheld that. Then there was a challenge. And in this case, there was some modification with regard to the consequential seniority. So far as the reservation in promotion is concerned, that was upheld by the division bench also. This is the position as of today. And there is no appeal against this before the Honorable Supreme.
Yes.
So these being the position, my lord, so far as the second relief sought for in this writ petition is concerned, my lord, possibly there is no cause of action survives because after that 2016 another OM came into force that was put to challenge, then that was negated, then a writ appeal was filed, writ appeal also no relief was given to them.
So any OM after this 2016 OM?
Yes, there is a third now fresh OM of 2000, my lord, 23. 18th of January, my lord, that is again put to challenge and is pending before the single judge. Awaiting judgment. That is on the issue of consequences, not so far as reservation in promotion is concerned, that has not been put to challenge, my lord.
No, but is it an exercise in line with the case of journal?
No.
There, since I appeared, the government, the division order went in terms of the reserve. And they were confirmed the consequential seniority in terms of the 77 and 85th amendment. The Assam government did not want to confer that. They came out with an OM. We challenged it on the ground when there is a judicial order of the single judge. Executive orders cannot nullify the order. So that has been, we are awaiting. That subject matter is not that is not related to this. This is absolutely on the post-based reservation. So the last effective, this memorandum is of 2016. Last memorandum.
Last memorandum, my lord,
Is of 2016.
2023.
Were taken away.
Just, my lord, last memorandum providing for reservation in promotion because there your lordships are correct. In the judgment passed by the single judge, there is A.D. Chaudhary, my lord. There was a paragraph which says that the state is at liberty either to provide for reservation in promotion with consequentiality or not to provide for reservation at all, or to provide reservation promotions without consequentiality. So taking, my lord, taking the aid from this particular paragraph of judgment, the state government has come up with a fresh OM of 18th of January 2023. And the first paragraph of that OM says, my lord, the policy of reservation in promotion shall continue.
Yeah, that's right.
This has not been put to challenge by Equality Forum, but then in respect of the catch-up theory which has been introduced here, my lord, there is a challenge and the petitions are pending.
So the last effective reservation, this OM is of 2016.
23, my lord.
23 is in relation to.
No, my lord. It says a reservation promotion shall continue.
Well, that's, they have continued it, but the last, whatever the excise on the basis.
2016.
Of
16.
Of 2016.
16, my lord. And that has been upheld.
Next time when they initiate a protest, someone arrange for that, maybe they are. My lord has raised a pertinent query, which I'm communicating. See, since there is a notification of 2016, which brings in the quantifiable data, which is the basis of all the arguments advanced. So there is no quarrel with the law laid down in Indra Swani or Jarnail Singh or in the subsequent decisions. But the fact remains that there was a notification which brings in the data. That notification having been put to challenge has been upheld. Division bench also upheld the order, so it has attained finality. So at least in 2016, there was quantifiable data. Now, if you say that even in the future, as and when they want to initiate a promotional process, every time they'll have to do it on the basis of data. That will be a future cause of action.
In 2016, my lord, there was no quantifiable data. There was no quantifiable data.
That there was, therefore they issued the office memorandum.
No, my lord, they don't have, without the, my lord.
And the learned single judge has held this. That whatever the exercise they had done, that is in consonance with the Jarnail Singh judgment.
Roman 5 and page 160 is clearly written.
There is no quantifiable
Collection
data.
of quantifiable data. Please.
The determination of cadre as a unit of collection of quantifiable laid down in OM confirms the mandate of Jarnail Singh and I am Raghunath, therefore same is upheld.
Yes, my lord, but it doesn't say that, my lord, there was quantifiable data, and on that basis, my lord, state has formed an opinion. That is not that, my lord.
This is what the challenge you have put to challenge that office memorandum.
Yes.
That was under challenge in that petition.
True.
Wherein the learned single judge has held that yes, this quantifiable data is there and that is in consonance with the judgment of the Honorable Supreme Court.
It doesn't say, my lord, there was quantifiable data.
It says, sir, the determination of cadre as a unit for collection of quantifiable as laid down by the so-and-so confirms the mandate of so-and-so, therefore same is upheld.
No, my lord, the court says that, my lord, that data is not required, and that's why, my lord, we went on.
That
appeal.
data is not?
That data is not, that quantifiable data is not required. It doesn't mean the single judge. And my lord, in all these cases, my lord, in fact, my lord, the position after 2016 ought to have been different. Because, my lord, I was, my lord, also submitting while pressing the division bench judgment of the coordinate bench that, my lord, this is for incurring the Honorable Supreme Court judgment. Now, my lord, what happens? Because
Sir,
there was, my lord, I'm sorry.
Again, sorry for interruption. This para number 6, Roman 3. The OM dated 3/6/2016 is notified laying procedure for collection of quantifiable data on backwardness and inadequacy of representation and determining efficiency in administration, while giving effect to such policy of the providing reservation. Given the dicta of Jarnail Singh, OM so and so cannot sustain so far, same reveals a collection of data of backwardness. But regarding efficiency and that has been upheld.
Yes.
So.
And my lord, the quantifiable data that has been, my lord, discussed, I'll, my lord, go through your lordship, we go through the, my lord, the notification also and the judgment. It has to be, my lord, by the departmental promotion committee. Your lordship
That
will
is for
read
the future exercise.
That being the position of the court unhesitantly holds that, I am reading 3, that the policy of providing reservation and promotion with consequently being holding the field as per OM dated 12/2020, the state is not within the competence jurisdiction to deprive such service benefit to meritorious reserved category candidates, and that too without expressly bringing such policy by superseding benefit given by referring to 2002 notification. Now, the collection of quantifiable data has been left to the my lord DPC, and that is where my lord the honorable single judge has said that my lord the requirement is satisfied. And my case all through is that, my lord, on the basis of the data, the state has to form an opinion. It's not the DPC.
Have you challenged this order of the division bench
No, no, my lord, but
that has attained finality?
yes, my lord. My submission before your lordship is that is for inquiry in the honorable Supreme Court judgment. I'll try to satisfy your lordship on that. In the division bench judgment, my lord, although M. Nagaraja has been, my lord, mentioned in 3-4 places, but only with regard to the, my lord, finding of the honorable single judge in equality forum 1 case, and without going into the, my lord, the principles that have been laid down.
Look, Mr. Chaudhary, see, please appreciate the query. This matter has several facets. We are not into all the gamut and entire gamut of the exercise. We are only on one simple point. It has been the consistent argument of yourself and Mr. Bushaw that these provisions and the Amendment Act of 2012 are bad because it does not follow the dicta of Janal Singh and M. Nagaraj in as much as there is no quantifiable data on the efficiency factor and I think the representation.
Yes.
Which is a sine qua non, a condition precedent before carrying out the exercise of
That is my
promotion.
point, my lord, yes.
Now, rightly or wrongly, in 2016, the government appears to have issued an OM, which according to them brings on the table the quantifiable data. This was put to challenge. The learned single judge has not only recorded a finding that the OM actually deals with quantifiable data, but also finds that it is in consonance with the law laid down in Janal Singh and M. Nagaraj. That decision having been taken in appeal, the writ appellate court, on whatever be the ground, has upheld the judgment. What is binding on the court is the principle. But the fact remains that the decision of the single judge has been affirmed.
Yes.
Correct.
Yes.
So as on today, it is now final that the OM of 2016 does bring in quantifiable data, which is a condition precedent for carrying out the exercise of promotion. And that has attained finality. So in view of 2016 OM, perhaps you cannot now challenge the 2012 amendment and far less the 1978 Act, Section 5. All you can say is that when a future exercise is again initiated for promotion, you can possibly argue that before this exercise is taken to its logical conclusion, a fresh collection of quantifiable data and determination of the promotion quota is required to be made. But that is an exercise which can be, that is an issue which can be called into question by the individuals who are affected, and that too as and when the process is initiated. In view of 2016, how can the court strike down 1978 Act or 2012 amendment? That's the question we are putting to you. That's all.
Yes, my lord. I understand your lordship's query, my lord. For that, my lord, we need to go to the, my lord, office memorandum of 2016. Because, my lord, it does not say that quantifiable data has been collected. It only
The
leaves
judgment
it.
of the single judge says so. The judgment of, please read that paragraph.
Your lordship will kindly read the, my lord, OM.
OM said rightly or wrongly that has been upheld, and up to the division bench that has not been interfered with.
My lord, my submission is,
Now
my lord,
your petition challenging the provision in this section 5 or 5A has become redundant.
no, my lord, in all these cases, my lord, that the act was not.
Pertinent issue has come up since I am one of the
Quantifiable data.
that there is a paragraph which my has stated in paragraph 6, the government of Assam has stated as to the manner in which the quantifiable data will be collected. It says it shall be the responsibility of the concerned appointing authority to provide adequate information to the selection committee, the DPC,
which shall evaluate all the relevant parameters while making its recommendation. Supreme Court in Nagraj Journal 1 and 2 has held that the DPC will go into the inadequacy of representation, and inadequacy of representation is the cadastre. So that will be looked into by the DPC. If the petitioners association has some problem with it, why have they not challenged paragraph 6 of OM of 60? Because that is the formulation of the OM, which says that this is how the cadre quantifiable data will be collected.
But they have challenged that.
Malad, they have not challenged. They have not challenged that. They have challenged that part by which we have challenged, not they. We, some benefits were denied to us as members of the reserve.
No, in latest petition. In latest petition. Or in the earlier petition.
No, they have not, in the latest petition,
Bhagwan
they have
Petor.
they have not.
They never challenged. They were never challenged. We challenged.
Reserve category.
Well, it is unheard of.
All petitioners are reserve category.
All
But a general group is challenging a benefit given to the reserve. Possibly this is the petition, only petition in India to my knowledge. And they were talking about nepotism and favoritism.
My fundamental rights has been violated. Yes, that's why I'm before you.
But reservation is constitutionally compliant, not violating of.
Can I, my lord, reply to your lordship?
If I read the petition logic, they say it is violating of 14. On that ground, my lord, I will pray that this petition should not only be considered. When I make my submission, I'll just see.
Yes, Mr.
My lord, this honorable Supreme Court has said, my lord, state in every case has to produce the records to satisfy the court that there was quantifiable data, and my lord, they have formed an opinion, let them produce the record, my lord. I'm repeating it again and again, my lord, they don't have any quantifiable data. Before, my lord, they issued the 2016 notification.
Just one small question.
Well.
Are your clients happy or unhappy with OM dated 3/8/2016? We want to just know that.
They are not, my lord.
You are not,
They are not.
but you have accepted it. You have
My
not
lord,
challenged
the
it.
question is, my lord, when this, the time passed, this is a 2013 petition, my lord. In the meantime, my lord, many persons have retired, my lord, those who came. So, my lord, on principle, the case remains. On principle, it remains, my lord. And therefore, my lord, it was not challenged before the Supreme Court. But then, my lord, I want to satisfy your lordship, my lord, even the Supreme Court judgment has not been, my lord, implemented in this, my lord, notification. That's why I say that this is per inquiry, the Honorable Supreme Court judgment. The division bench judgment.
Withdraw and make a fresh challenge.
Many persons have retired.
Continue.
Then you can do one thing. You are aggrieved by this notification of 2016. You have a separate cause of action. Now you are saying that 2013, many of persons have retired and some new persons are there and they are aggrieved. They may file a fresh petition.
No, my lord, my submission with your lordship is that your lordship will only determine, my lord, whether the mandate that has been, my lord, laid down by the Honorable Supreme Court in, my lord, Nagraj and the, my lord, Journal Singh, whether, my lord, that has been complied with.
That has been complied with, that may or may not have been complied with. The state has come with the office memorandum, which was put to challenge, that has been upheld. Now what remains?
My lord.
At
my
that
lord,
time,
so-
2013, certainly there was no such exercise by the government, but later on, if they have done it and that has been upheld, then what remains to be decided in this petition, sir? Subsequently,
My lord,
whatever, rightly or wrongly,
in all these cases, my lord, the act was not under challenge. In earlier provisions, only office memorandum, some provisions of it. My submission with your lordship is that after 1992, when, my lord, the 9 judges bench, that impersonation case, my lord, was decided, it was incumbent on the state to, my lord, revisit the 1978 Act. We did not have, my lord, any occasion to challenge that prior to, my lord, 1992. After 1992, what happened, my lord? My learned friend was saying about Sabharwal. Sabharwal was, my lord, it was decided on 10 to 1995 before the, my lord, 77 amendment came in. There were many cases before the Supreme Court. 77 amendment, the 81st and 82nd and 85th amendment, law crystallized only when my lord Nagaraj's judgment came in my lord
2006.
2006. And then only, my lord, thereafter, this whatever notification they, my lord, use, that has to be, my lord, that has to satisfy the taste that has been laid down by Nagaraj and my lord journalists.
That is what the learned single judge has said. That is the learned single judge has said.
Now, my lord, the question
That
is,
is that in the determination of cadre confirms the mandate of General Singh and Nagaraj.
my lord, that's why I say that, my lord, that judgment of the division bench is for inquiry. Ultimately, your lordship will need ultimate analysis.
You were the appellant in that case and you have not challenged that, and now you are pressing this petition.
Because, my lord, I am challenging the act now, my lord. It's not that, my lord, the notification. Because after 2000, my lord, Nagaraj's case, my lord, they ought to have to revisited it. And where does this, my lord, figures?
Just,
So, my only one sentence, my lord, thereafter we submit, only one sentence,
just-
because there is no point repeating my submission, my lord. What I say is that after the law crystallized after Nagaraj, my lord, it was incumbent on the state to go for the, my lord, go for a new act. Because, my lord, 1978 act was prior to all these amendment of the constitution, all the judgments of the Supreme Court. Now, your lordship had put a query, my lord. Section 5 cannot be gone into. It's only, my lord, section 5A, we are agreed that. I say that, my lord, section 5A, when we examine that, my lord, we have to go to the root. Root is in section 5. Where does this figure, my lord, 7%, 5%, 10% comes in, my lord?
Oh, that was at that time there was nothing.
Yes, my
with
lord.
the government.
Therefore,
But later on, if they have done certain exercise and that has been upheld.
yes. Therefore, my lord, as my lord things stand today, as the law stands today, the act cannot stand. That is my case, my lord. I'll not repeat, my lord. This is my case.
Okay.
Well, one submission, it appears penalty now the petitioners are relying on only one principle of par inferium. Par inferium, subject to correction, my lord, is a concept which says that if a judgment has been passed without referring to a particular judgment which has got a different view, then it may be a part. Here, my lord, the Nagaraj and all were taken into consideration, and the view has been taken. Now, if you are not satisfied, and if you are agreed, go for an appeal before the Supreme Court. Now you cannot say par inferium. Your submissions were recorded. A finding was recorded by the division bench, my lord. It's not a case of par inferium.
I'll, my lord, reply to that, if your lordship permits me. My lord, Nagaraj's case had been noticed, mentioned in the judgment only in relation to the, my lord, finding of the equality one forum case, not the principles have been discussed. I'll show, my lord, from the, and my lord, on, my lord, the point of what inquiry, I'd like to place a judgment of the Honorable Supreme Court. This is, my lord, 2004 SCC 262. I'll read paragraph 8 only, my.
Yeah.
Learned counsel for the respondent attempted to convince us that the decision in the case of State of AP versus Sundararaman has to be ignored on the principle of par inferium, as certain relevant provisions of the rule were not considered in the said case. And in any case, This case requires to be referred to a larger bench of 3 judges. The rule of par inquirium can be applied where a court omits to consider a binding precedent of the same court or the superior court rendered on the same issue, or where a court omits to consider any statute which while deciding the issue. This is not the case here. Instead of so and so, this is the principle, my lord. Now, my lord, I'd like to show your lordship, my lord, the judgment of the, my lord, coordinate bench, where although, my lord, Nagraj has been said, these principles have not been touched. The basic principles, the basic guidelines that has been, my lord, laid down, that has not been discussed at all by the division bench, coordinate bench.
So, Mr. Chaudhary, if your argument is to be accepted, then at best, the division bench judgment is a bad judgment. It's not a per incuriam judgment. If the language is not happily worded and the findings are not properly recorded, that doesn't make it a per incuriam judgment.
My lord, yes, I
That
understand,
is
my
at
lord.
best a bad judgment, which is liable to be assailed.
My lord, my submission is that although Nagraj has been mentioned in 3-4 paragraph, I'll come to that, my lord. The main principle has not been touched, my lord. The principles that have been laid down that have not been touched.
Correct.
If I may refer to, my lord, in 3-4 paragraphs, Nagraj has been said.
Page 12, 13.
There, my lord, Nagraj has been mentioned only in relation to the finding of the single judge in earlier repetition, WPC 1560. In this judgment,
Yes,
my lord, the Nagraj has been referred to only with regard to the, my lord,
you are referring to single bench judgment or division? bench?
division bench judgment.
Division bench.
Right. I.P. Borgohain, R.B. Gohain Das Gupta. My submission will be that, my lord, in certain paragraphs it has been mentioned, Nagraj, and why that has been mentioned only to, my lord, nullify what was there in the, my lord, or the first equality one judgment.
Yes, which para?
My lord, in this judgment, Nagraj finds place in paragraph 8, 9, and 25 particularly. Paragraph 8, your lordship will kindly read. WPC number 1560 of 2025, that was Equality Forum case, and WPC so and so were instituted by Registered Society in the name of the Equality Forum and for other persons serving as assistant engineer in the irrigation department, seeking promotion to the next cadre of assistant executive engineer respectively. In both the writ petitions, an issue was raised as per the judgment rendered by the Honorable Supreme Court in M. Nagraj and others, so and so reported in so and so, UP Power Corporation. There is a requirement of the state to have a quantifiable data on the backwardness and inadequacy of representation of the reserved category candidates for the purpose of promotion. According to the petitioners in the said writ petitions, in the state of Assam, no process was initiated for obtaining quantifiable data as required in M. Nagraj and UP Power Corporation, apart from the report of one-man committee comprising of Sri H. Sonomal, the then Commissioner and Secretary of the Government of Assam in the welfare of plains and backward classes, which report was also inadequate and unacceptable, and as such, further continuation of the provisions of the reservation and promotion as well as providing for consequential seniority would be unsustainable in law. In the said two writ petitions referred as Equality Forum as reported in 2016 1 GLT by the judgment dated 23/12/2025 in paragraph 47 thereof, it was provided that till the exercise of collection of quantifiable data relating to 3 constitutional requirements of backwardness of the class, inadequacy of representation in public service, and overall efficiency in the administration in the event of reservation, as mandated in M. Nagraj and UP Power Corporation, is done, and an opinion is formed by the state based upon the quantifiable data so collected as to whether the enabling provision of Article 16(4)A is to be invoked. Reservation and promotion would remain in a dormant state. In paragraph 77 of the judgment in Equality Forum is extracted below. There, my lord, that has been accepted. Then paragraph 10, pursuant to the judgment that is so and so, the Government of Assam and the Department of Welfare of Plain Tribes and Backward Classes issued a office memorandum dated 3/8/2016 The opening paragraph of the said office memorandum dated 3/8/2016 provides that it was issued as per the guidelines laid down by the Honorable Supreme Court in M. Nagras and UP Power Corporation. Thereafter, in the first paragraph itself, reference is made to the report of the one-man committee appointed by the government of Assam for collecting quantifiable data, which was assailed before the High Court in Equality Forum Supra. And accordingly, the provisions of the judgment dated so and so is referred as quoted. The subject matter of the office memorandum dated 3/8/2016 is stated to be review of the government policy of reservation in promotion with reference to the Honorable Guwahati High Court judgment. Then the, my lord, entire office memorandum has been, my lord, quoted, and here, my lord, your lordship will not find in the office memorandum that, my lord, quantifiable data has been collected, and thereafter my lord, an opinion has been formed. So there, my lord, after quoting, there is no discussion on the judgment of the Honorable Supreme Court in M. Nagras. And finally, in paragraph 25, Mr. D.K. Das, learned counsel also refers to judgment in Supreme Court in rendered in M. Nagras, wherein in paragraph 47, it has been provided that the collection of data as regards inadequacy representation of the reserved category candidates would have to be done cadre-wise, and submits that as the collection of data as regards inadequacy would have to be done cadre-wise, therefore there cannot be a centralized procedure set in place for collection of the data regarding inadequacy in representation, and such inadequacy would have to be determined cadre-wise and case-wise in respect of every such promotion under consideration in respect of any given cadre. That means there is no discussion on the principles that have been laid down. Therefore, my submission is that, my lord, both UP Power Corporation and M. Nagras have not been, my lord, considered by the division bench, and therefore this is for inquiry.
But the learned single judge has taken into consideration that Nagaraj.
Learned,
More than one.
that they have not gone to the, my lord, basic principle. Paragraph
Paragraph number 4 of the judgment of Bhagwan Potar.
Paragraph number 4, ratio, my lord, the Nagras has been mentioned. The discussion your lordship will find at, my lord, A.
Can be summarized.
Yes,
M. Nagaraj Supra,
yes. At, my lord, A, your lordship will find.
Jarnail Singh,
Yes,
all the BK Pavitra, Jarnail Singh first, second, BK Pavitra, all.
yes,
the
this has been
judgments were
discussed,
taken
and my
into
lord, finding is
consideration,
at,
sir.
my lord, serial number A. Findings are there, my lord. Whether by issuing the impugned OM, the state has not followed the mandate of M. Nagaraj and Jarnail Singh and Equality Forum by not collecting quantifiable data and therefore liable to be struck down. Now, my lord, there is no finding that, my lord, the quantifiable data has been collected. It's not there.
That is the only finding. That is the only finding of the learned single judge.
No, what I submit is that, my lord, Supreme Court has said in every case the court, the state has to, my lord, satisfy the court. Let them show, my lord, there was quantifiable
The
data.
learned single judge was satisfied enough.
And I am not, my lord, filing an appeal against this. I am not arguing an appeal against this judgment. I am saying that, my
But
lord.
we are bound by the division bench judgment until and unless you able to persuade us to take a different view.
And, my lord, here the act was not under challenge. And, my lord, even today, my lord, if they can show that there was quantifiable data, then your lordship will need not interfere in my reputation. They don't have any. It is also, my lord, stated in A Roman 3, the state needs to collect data on inadequacy representation while affecting the provision of Section 5 of the Act 1978. If the data collected reveals that there is adequate representation in the cadre, the state cannot provide reservation and promotion. And your lordship will kindly see, my lord, Roman 4, third paragraph. The office memorandum further reflects that the policy of reservation of the state shall continue, meaning thereby that the policy of reservation in promotion mandated in Section 5 of the Act 1978 shall continue in as much as the Act 1978 is still holding the field and not under challenge in the present list. So all the findings are based on this, my lord, the Act was not under challenge. Subpara 3 of Roman 4 under A. So the decision in this judgment has to be, my lord, understood in the context of the fact that, my lord, Act of 1978 was not under challenge. So if the Act is there, this is everything is hanky-dory. My lord, I don't have any further submission to make. My lord, if your lordship permits me, then I can give a written argument. My lord, if your lordship permits me. My lord.
You have argued for more than 2 hours, what?
No, my lord, if your lordship permits, my lord, if your lordship feels that it's necessary, my lord, then we'll fight. But I'll not take your lordship time, more time, my lord. Otherwise, it will be a repetition of what I am saying. Some
Yes.
If I, in detail, I have to argue, I'll have to show from the R.K. Sabharwal that the post-based roster amendment made in 1978 is totally based on the R.K. Sabharwal judgment. And I can show from the R.K. Sabharwal judgment manner what is post-based roster and whether they can challenge this amendment of 2012 without challenging R.K. Sabharwal judgment.
How will they challenge nine judges Supreme Court judgment?
My lord,
Not by filing a writ petition in this court.
my lord, that's what I'm saying. What I'm saying is, my lord, the amendment of 2012 is a reflection of the R.K. Sabharwal requirement that there has to be post-based roster and not vacancy-based roster. This was introduced by an amendment of 2012 in the 1978 Act. They have challenged it, my lord, as I have pointed out, my lord. The challenge is not because the amendment is bad. Challenge is because by executing or implementing that post-based roster system, my lord, there has been an excess of reservation. It's a different thing. And this on this basis, my lord, an act cannot be challenged. A provision of the act cannot be challenged. Your lordship's desire, my lord, I can read this R.K. Sabharwal judgment, my lord.
My lord, much water has flown after R.K. Sabharwal judgment. All these amendments came, my lord, only after Sabharwal. Only after Sabharwal, my lord.
I'll read only 2-3 paragraphs that will suffice, my lord.
Yes.
Paragraph 1, I'm reading first, my lord. The petitioners and respondent number 4, 5, and 6 are members of Punjab Service of Engineers Class 1, the service in the irrigation department of the state of Punjab. The respondent are members of scheduled caste, whereas the petitioners belong to the general category. Conditions of service of the members of the service are governed by the rules called the Punjab Service of Engineers Class 1 PWD IB Rules 1964. The Punjab government, by the instructions dated 4/5/1974, provided reservations for the scheduled caste and backward classes in promotions to and within Class 1 and Class 2 services under the state government. it was laid down under the said instructions that 16% of the posts to be filled by promotion were to be reserved for members of scheduled caste and backward classes, 14% for the scheduled caste and 2% for the backward classes, subject to the conditions that the persons to be considered must possess the minimum necessary qualifications and they should have satisfactory record of service. The instructions further provided as under, in a lot of 100 vacancies occurring from time to time, those falling at serial numbers mentioned below should be treated as reserved for the members of scheduled caste 1, 7, 15, 22, 30, 37, 44, 51, 58, and so on. Vacancies falling at serial number 26 and 76 should be treated as reserved for the members of backward classes. Now the rest we can skip. Lordship may just turn to the next page, my lord. The second part, but my lord, last paragraph, it is stated in the writ petition that petitioners are at serial number 19, 23, 26, 29, 30, 31, 34, and 38 of the seniority list of service, whereas respondents are at serial number 46, 140, and 152. Respondent so-and-so was promoted to the rank of chief engineer against the post reserved for the scheduled caste by superseding 36 senior colleagues, including the petitioners. Similarly, respondents Sujit Singh and Om Prakash were promoted as superintending engineers against the reserved vacancies by superseding 82 and 87 senior colleagues, respectively. According to the petitioners, at the time of promotion of these respondents, the petitioners were already working as superintending engineers for several years. It is further averred in the petition that respondent number 4, 5, and 6 were in fact working as executive engineers when the petitioners were holding the post of superintending engineer. On the above facts, the petitioners have challenged the reservation policy on several grounds, but Mr. So-and-so, the counsel for the petitioners, has confined the arguments to the following 2 points. 1. The object of reservation is to provide adequate representation to the scheduled caste, tribes, and backward classes in the services, and as such, any mechanism to provided to achieve that end must have nexus to the object sought to be achieved. The precise argument is that for working out the percentage of reservation, the promotees stroke appointees belonging to the scheduled caste and backward classes, whether appointed against general category posts or against the reserved posts, are to be counted. Now, this is very important. In other words, if more than 14% of the scheduled caste candidates are appointed stroke promoted in a cadre on their own merit, seniority, by competing with the general category candidates, then the purpose of reservation in the said cadre having been achieved, the government instructions providing reservations would become inoperative. While I'll avoid the second issue, my second point is not relevant here. Now, Lordship may kindly turn to para 3, my lord. Adverting to the first point, so and so, learned counsel representing the petitioners have contended that the total number of promotees stroke appointees belonging to the reserved categories in a cadre are to be counted to work out the prescribed percentage of reservation. According to the learned counsel, the reserved categories can take advantage of the reservation made in their favor till their representation in the service, including those appointed against general category posts, reaches the prescribed percentage. For working out the percentage, the promotees, appointees belonging to reserved categories in the service, whether on the reserved posts or general category posts, are to be counted. This is the argument, madam. Support is sought from the judgment of Punjab and Haryana High Court in so-and-so. In the said case, 22% reservation was provided for the members of scheduled caste, tribes, and backward classes. In the cadre strength of 202 posts, the scheduled caste candidates were entitled to 42 posts. There were already 47 members of the said category in the cadre, but out of them, 10 were promoted on the basis of seniority cum merit against the general category posts. There being only 37 persons who had been promoted against reserved posts, 4 more scheduled castes were sought to be promoted against the reserved vacancies. The High Court quashed the promotion on the ground that the cadre was already having more than 22% from the reserved categories. We are of the view that the High Court in so-and-so fell into a patent error. The said case was subsequently considered by a full bench of Punjab and Haryana High Court in so-and-so. The full bench did not agree with the ratio in Joginder Singh. Now, this is important. Paragraph 4 is what the post-based roster is known for. When a percentage of reservation is fixed in respect of a particular cadre and the roster indicates the reserve points, it has to be taken that the posts shown at the reserve points are to be filled from amongst the members of reserve categories, and the candidates belonging to the general category are not entitled to be considered for the reserve posts. On the other hand, the reserve category candidates can compete for the non-reserve posts, and in the event of their appointment to the state post, their number cannot be added and taken into consideration for working out the percentage of reservation. Article 16(4) of the Constitution of India permits the state government to make any provision for the reservation of appointments or posts in favor of any backward classes of citizens, which, in the opinion of the state, is not adequately represented in the services under the state. It is therefore incumbent on the state government to reach a conclusion that the backward classes for which reservation is made is not adequately represented in the state services. While doing so, the state government may take the total population of the total particular backward class and its representation in the state services. When the state government, after doing the necessary exercise, makes the reservation and provides the extent of the percentage of posts to be reserved for the said backward class, then the percentage has to be followed strictly. The prescribed percentage cannot be varied or changed simply because some of the members of the backward class have already been appointed or promoted against the general seats. Now, this is important matter. As mentioned above, the roster point which is reserved for a backward class has to be filled by way of appointment or promotion of the members of the said class. No general category candidate can be appointed against a slot in the roster which is reserved for the backward class. The fact that considerable number of members of backward class have been appointed or promoted against general seats in the state service may be a relevant factor for the state government to review the question of continuing reservation for the state class. But so long as the instructions or rules providing certain percentage of reservation for the backward classes are operative, the same have to be followed. Despite any number of promotees or appointees belonging to the backward classes against the general category post, the given percentage has to be provided in addition. We therefore see no force in the first contention raised by the Learned Counsel and reject the same. So the main argument that if certain persons belonging to a reserve category are already there in a particular cadre, then it has to be presumed that their percentage of reservation is already achieved. No further reservation is to be given. That was rejected. And that is why I meant the replacement formula. A post reserved for a particular category has to be filled up by that category only and not by general category candidate. Then just lastly the paragraph 10 once minor. Just given the example manner. Paragraph 10.
Yes.
We may examine the likely result if the roster is permitted to operate in respect of the vacancies arising after the total posts in a cadre are filled. In a 100-point roster, 14 posts at various roster points are filled from amongst the scheduled caste and scheduled tribe candidates. 2 posts are filled from amongst the backward classes, and the remaining 84 posts are filled from amongst the general category. Suppose all the posts in a cadre consisting of 100 posts are filled in accordance with the roster by so and so. Thereafter, in the year 95, 25 general category persons out of 84 retire. Again, in the year 96, 25 more persons belong to the general category retire. The position which would emerge would be that the scheduled caste and backward classes would claim 16% share out of the 50 vacancies. If 8 vacancies are to them, then in the cadre of 100 posts, the reserve categories would be holding 24 posts, thereby increasing the reservation from 16% to 25%. On the contrary, if the roster is permitted to operate till the total posts in a cadre are filled and thereafter the vacancies falling in the cadre are to be filled by the same category of persons whose retirement, etc., cause the vacancies, then the balance between the reserve category and the general category shall always be maintained. We make it clear that in the event of any non-availability of reserve candidate at the roster point, it would be open to the state government to carry forward the point in a just and fair manner. So this was the basis why the Honorable Supreme Court in this judgment, my lord, 5 judges constitutional bench decided that in future there will be a post-based roster and not a vacancy-based roster. And thereafter, my lord, in 2012, of course, soon thereafter it was not made. In 2012, this amendment was introduced. Lordship will kindly see this amendment in the Act 5A. It says, my lord, the reservation for members of scheduled caste and the scheduled tribes in services or posts in an establishment shall be given effect to in the following manner, namely, a post-based roster shall be maintained to give effect to the reservation of vacancies for scheduled caste and scheduled tribe. And this amendment was made in Section 5 also, my lord, in subsection B. And then 5A, my lords will find 5A. Five A says, the reservation for the members of the scheduled caste and the scheduled tribes in services or posts in a establishment shall be given effect to in the following manner, namely, a post-based roster register shall be maintained to give effect to the reservation of vacancies for scheduled caste and scheduled tribe. Such roster shall be based on the model roster as per Schedule 1 and 2 appended to this Act and shall be adopted for the purpose by each establishment in such manner that the prescribed percentage of reservation is maintained in each cadre. Then Lordship will kindly see Roman 3. The roster is to be operated on the principle of replacement and not as a running account. In other words, the points at which reservation for different categories applies are fixed as per the roster, and vacancies caused by retirement, etc., of persons occupying those points shall be filled up by appointment of persons of the respective categories. So this replacement theory, post-based roster,
Just a minute. 5A3. 5A3. Serve the embodiment of the exercise has been just to constantly
Well, my submission to your lordship is, my lord, so far as the first relief sought in the writ petition, both the writ petition is concerned, my lord, the challenge is to the amendment of 2012, my lord, the entire
You have
amendment.
already mentioned that.
My lord.
As per the R.K. Sabharwal's
Yes.
mandate.
Yes. And the second, so far as the second relief is concerned, my lord, so far as the first petition filed by Equality Forum is concerned, my lord, now, in my humble submission, my lord, no cause of action survives so far as the second relief is concerned because they have subsequently changed the very reservation policy. Whereas Section 5 is what? Section 5 is the extent of reservation provided in the Act. Entire Act is not under challenge. Now, this reservation promotion subsequently, my lord, spelled out by the state in the form of an OMA of 2016 was put to challenge. That was not accepted. Then a writ appeal was filed. That was also not accepted. Then today, my lord, when this argument is made that it is par incuria, my lord, lordship has seen in the judgment passed by one single judge as well as the division bench, my lord, in several paragraphs, the judgment of Nagaraja and R.K. Sabharwal and V.K. Pavitra are referred. It is not a case where the judgment was passed being oblivious of the Nagaraja judgment. It was referred and a view was taken. If you are not satisfied with the view, you are always entitled to file an appeal before the Honorable Supreme Court. That we have not done. And so far as the second petition is concerned, my lord, there I have pointed to my lord, his grievance is not the, my lord, act itself, or his grievance is the excess reservation. So that being the position, my lord, in such a petition, my lord, lordship will not strike down an act when the Honorable Supreme Court has, in a plethora of judgments, said, my lord, there is always a presumption in favor of validity of a legislation, unless they show something to the contrary. That's
Submission of the additional act.
Give combined reply to submission of the additional Advocate General.
May it please your lordship. My appeal for the sum of the reserve. Well, my first contention is that this petition filed by the association is misconceived in view of the Supreme Court's order that the members of the reserve, because they are challenging an OM, they are challenging a benefit given by a Supreme Court in the R.K. Sabharwal case from vacancy base to post base. Well, what right is violated of the, because they are members of the generals.
In fact, if your lordship sees the prayer portion, the lordship will find that what they want that all promotions in all cadres need to be stayed. In all cadres of executive engineer, superintendent engineer, well, I would have understood if the petitioner had some grievance regarding excessive reservation, because the general has no grievance on reservation because it is constitutionally permissible. In fact, if your lordship finds that in the prayer portion, they want that the post-based reservation given to in Assam under the Act of 2012 needs to be struck down along with the Act of 78 is totally misconceived for the simple reason they have themselves have said in their own petition they want implementation of post-based reservation in Assam. Well, your lordship will come to their petition. Well, we expect some semblance of your lordship will come to paragraph 17 of the petition, Equality Forum. Lordship will find at page 17, para 17, at page 19, that the petitioner begs to state that the post-based roster should be implemented with effect from the judgment passed by the apex court in R.K. Sabharwal, while therefore preparing the roster in such a manner, if there is an excessive representation of any reserve, it should be adjusted in future recruitment. Well, first of all, para number 17 at page 19.
19.
Yes, lordship, of the writ petition 4034. The Equality Forum case.
Page 19.
At page 19, lordship, para 17.
Yes.
My lord, if I may read, lordship.
Yeah.
That the petitioner begs to state that the post-based roster should be implemented with effect from the judgment passed by the apex court in the R.K. Sabharwal case, while thereby preparing the roster in such a manner, if there is an excessive representation of any reserve class, it should be adjusted in future recruitment. My lord, if there is excessive reservation, the law is very clear. You cannot have an excessive reservation. It must be within the prescribed percentage. Except on merit in paragraph 4 of R.K. Sabharwal. On merit, when we go as a member of the unreserved. No one can stop us. And number 18, my lord, that's it's really ridiculous, my lord. They say that the respondent authorities have sought to act in a high-handed and unreasonable manner. The whole process smacks of malafide and evident existence of favoritism and nepotism towards the reserve candidate. My lord, my submission is that for the past 75 years, if this petition is accepted, we'll have to hold that reservation in India, which is a mode of achieving equality, is now being reduced to favoritism and nepotism to the SC and the ST. And secondly, lordship, your lordship will find that this petition has been, the roster was challenged in the Guwahati High Court 30 years back. In fact, in that petition, section 75 of the 78 Act was challenged. But the petitioner's counsel, who was a very prominent counsel of Guwahati High Court, he made his submission and he put a caveat that insofar as the competence of the 78 Act, I will not argue. Lordship will take up that case. The compilation at page 26, Lordship, the judgment is at, this is a matter of a tax department, a tax matter, like the second case, page 20 it starts. It's a division bench matter of the Guwahati High Court. Yogeshwar Das. 1998 High Court 366.
Yes.
Lordship will find that 14 and 15 is the operative part. Paragraph 15 at page 26. Sri Bhachaji, learned counsel for the petition. Here the roster promotion given to the reserve was challenged by the general.
Yes.
Para 15, Sri Bhachaji, learned counsel for the petitioner, means the general he represents, during the course of arguments, had not questioned the competence of the state to the act. It may be briefly noted that under item 41 of the state list in 8th schedule of the Constitution, Article 309 and 16(4) of the Constitution, the state has the competence to make provisions for reservation in appointment to posts in favor of state is not adequately represented in services under the state. The state therefore has undoubtedly the accessory competence to make the law, including the state provisions for roster. And Lordship, the ending part, Lordship, is at page 28, paragraph 21. Can I read?
Yeah.
For the aforesaid reason, we think that the impugned notification dated 7/3/81, whereby the respondent core belonging to scheduled caste had been appointed to the post of Assistant Commissioner of Taxes in pursuance of the aforesaid roster in the schedule to the act was valid. The petition fails and accordingly dismissed. So my contention is that this petition does not have the two elements which is required for making a challenge to a act. For legislative incompetence and fundamental rights. On two grounds, they cannot make any case. They don't have any case. So my first contention is that on this ground, this petition needs to be dismissed. My second ground is that I'm in full support of the submission made by the Additional Advocate General, Mr. Majumdar, that the Assam government took a conscious decision to implement R.K. Sabharwal. And in the division bench, Your Lordship, I've given an affidavit also, annex. Your Lordship, the Assam government stand that we will implement the post-based reservation in Assam was filed by the Chief Secretary of Assam, which is at compilation 30, page 30 of the compilation. Very specific. And the Chief Secretary, they filed it before the division bench. Lordship, at page 30, that the deponent is competent on behalf of the Chief Secretary, that the deponent begs to state that the scheduled caste and scheduled tribe reservation of vacancies in services and posts 1978 was amended in 12 to implement the orders passed by the Honorable Supreme Court in R.K. Sabharwal. The Assam scheduled caste and scheduled tribe reservation of services and vacancies and post act was published in the official gazette on 21st of August 2012, and it came into effect on 26/2/2013 by gazette notification of the appointed date. So after making a categorical submission by the state of Assam, the post-based reservation, which was being followed throughout the country from 97, and in Assam, 14 years lapsed. In fact, our case was we lost it. Many officers of the reserve did not get the benefit of post-based reservation because the Assam government implemented a bit late. So my submission is that since the categorical finding statement has been made before the division bench that the R.K. Sabharwal will be implemented, now to challenge virtually, if the challenge is allowed, my lord, the entire post-based reservation in Assam will collapse. And in fact, in all the submission made by the petitioners, both the petitioners, they make a submission that there has to be an exercise. My lord, exercise cannot be in the thin air. The three exercises which were supposed to be laid down in Nagraj, my lord, I'll show, Nagraj never went on the issue of reservation. Nagraj dealt with excessive reservation. That point has not been laid on. But I'll satisfy your lordship from the judgment of Nagraj that the entire submission of the petitioner is misconceived and erroneous because Supreme Court in Nagraj was basically looking into the validity of the challenge to the amendment of 77 and 85th, whereby accelerated promotion and consequential seniority were being conferred. Equality Forum, the national group, this is the state unit, they challenge it.
No, don't
It
say
lost.
fake unit. Don't say fake unit. Mind your words. You said fake
I
unit.
didn't use fake, state unit.
Oh, state.
But why will I use the word fake?
Right.
I know
Oh,
my,
Sorry, sorry.
the voice model. Well, your lordship will come to page 124 of the M. Nagraj. 190. In the Nagaraj case, paragraph 119 clearly shows that Nagaraj was on the, not on the issue of reservation, but on excessive reservation. My lord, the petitioners have not had not shown a single instance where they could show that the case which they have vouched is on excessive reservation. On excessive reservation, we know our limits. Yes, yes. Malad, if I may read only one paragraph, I won't trouble your lordship. Malad, Niagara's 119, if I may be. Existence of power cannot be denied on the ground that is likely to be abused. As against it, it has been held in paragraph certain of Keshwananda Bharati's case that where the nature of the power granted by the Constitution is in doubt, then the court has to take into account the consequence that might ensure by interpreting the same as an unlimited power. However, in the present case, there is neither any dispute about the existence of a power, nor is there any dispute about the nature of the power of amendment. The issue involved in the present case is concerning the width of the power, and its limitation, if any, must be found in the constitutional requirement, namely backwardness of the class, inadequacy of public appointment, and overall efficiency of administration. These requirements are not obliterated by the constitutional amendments. Reservation is not the issue. What is the issue is the extent of reservation. If the extent of reservation is excessive, then it makes inroad into the principle of equality on 16(1). Extent of reservation as stated above will depend on the facts of each case. Backwardness, inadequacy, or compelling circumstances of the state to provide in public employment. Therefore, if in a given case, the court finds excessive reservation under the state enactment, then such enactment will be liable to be struck down since it would amount to derogation. And it is that principle of paragraph 119 that three decisions referred by my learned colleagues will come into force. That situation is not in Assam. We are confining ourselves within the prescribed percentage. There is no case that there has been excessive reservation by the government, and so the reserve general are affected. Malad, in fact, the judgment referred in three cases: the PK Pavitra, Jarnail Singh 1, and also the last judgment UP Power. It is absolutely not applicable in our present scenario, because there was excessive reservation.
Mr. Das, you have declared a little while back that you are unstoppable. That's fine, but are you going to conclude today, or
I'll conclude.
you will conclude? How much longer?
By 4, I'll.
And how much time will you need, Mr. Busuk? Are you trying to stop him, or
Yes, then we'll.
how much time will you take?
Then I'll stop for the day.
No, we are not trying to stop
I
you.
thought I'll conclude here. Conclude it. Whatever it may be brief in your
Yes,
arguments and.
Mana, I'm brief.
We are not
So this
Yes.
point that there is a issue of reservation is not there. It is excessive reservation. And in fact, in their petition itself, the fact that the prayer and their averments are completely mismatched.
That
Goes to
they
show-
already pointed out.
Yes. Then the next submission which has been made is that the 2016 Lordship has rightly said that it has been upheld. If they had anything, they could have gone and appealed, they never went. The 2016 OM of the Assam government clearly states, I won't read it, I'll just briefly summarize, that it says that there should not be any confusion in any quarters that the quantifiable data which was done by the Sonwal committee, the policy part, there were flaws in the implementation of that as to how the data was to be collected. The reservation was never set aside, the government. So the reservation policy continues. And that has been clearly stated by the learned single judge in the division bench. And in conclusion, Malad, I'm summing up. In paragraph 40, query was, Your Lordship has rightly held that if the submission of the petitioners is to be accepted, it will be a never-ending process because they have always been making a submission, the mandate of Supreme Court, and data has not been collected, but they have not been able to give the solution. We want solution. The solution is in paragraph 40 of the division bench order of IV Gohain, where a submission made by me, I was one of the respondents, council
The court has accepted that.
accepted it and said that the DPC will be.
DPC,
Yes, well, then it will be a mockery that everywhere, every day data will be conducted and the government won't have any other work. And as regards my final submission, paragraph 43 of IV Gohain considers all the submission of my learned senior counsel and rejects all the three submissions. So in view of that, this petition needs to be dismissed. Fine. Since I have given a short compilation, a lot of people consider along with Supreme Court judgment.
So Vaishya, only reply to their arguments, no repetition of your.
My lord, I will not repeat, my lord. My lord, kindly consider my read petition, my lord. In the what I have challenged is the 1978 Act and the Amendment Act 2012
Yes.
at page 2. And kindly consider my clear portion, my lord. What my learned friend, additional advocate general is saying is not correct, my lord. My lord, what I am praying for is to issue a writ in the nature of statutory for setting aside and quashing the impugn Assam Scheduled Caste and Scheduled Tribes reservation of vacancies in service and post amendment act 2012. Section 5 of the 90s, then my lord, prayer 2, a writ in the nature of statutory, section 5 of the 1978 act.
Yes.
My lord, then 3 and 4 regarding the excess reservation, my lord, and the other, my lord, what I
So
will,
essentially, you are aggrieved by the access reservation.
no, my
Not
lord.
by the reservation.
No, I am aggrieved by the Reservation Act, which is not enacted or bringing, they want to bring in into force without satisfying the rider given by
Honorable
Nagraj,
Supreme Court in Nagraj and General Secretary.
my lord. And my lord, kindly consider one thing, my lord. 1978 Act was formulated under 16(4). And
That you have already
And
pointed
19,
out.
yes, my lord, 92, that was set aside. Then several judgment of the Supreme Court said that no promotion, with no consequential seniority. Thereafter, my lord, in 2000, that amendment, constitution amendment came into force, my lord.
16(4)(a).
My 16(4)(a), and and there, my lord, it was laid down, the state has to take the, from the opinion. My lord, without repeating that, my lord,
Mr. Concept.
my lord.
But now, in the year 2016, first of all, they constituted a one-man commission and submitted a report. That the report was set aside by the learned single judge. Thereafter, in the 2016, they formulated a formula or whatever it may be for this quantitative data and all. And that has been upheld up to the division bench. Now, what remains in this challenge?
My lord, the learned single judge and the division bench
Yes.
failed to consider that the state has not collected the quantifiable data, which is prerequisite.
That has.
My lord, the additional advocate general can say that they have produced the
Where is the question
quantifiable
of
data.
additional saying of additional advocate general when the judgment itself speaks about it?
No, my lord, facts remain, my lord.
Facts remain, what do you mean by fact?
Facts
It's the
remain,
finding by the learned single
quantifiable
judge
data,
upheld by the
till
division
that,
bench.
my lord, quantifiable data has not been collected. my lord.
That is the finding of the learned single judge.
Let them produce the record, man. Let the state produce the record. It will
There is
clarify
a question
everything,
of
my lord.
record. The learned single judge has satisfied himself that the data is there and that is in consonance with the true judgment of the Honorable Supreme Court. Division bench has upheld it. Now, again, you are saying the same. If you are aggrieved by that, then challenge this order.
My lord, what happened, my lord? In those read petition, act was not challenged. Act can be challenged before your lordship in division bench.
Where
My
act
lord,
was not
the-
under
the-
challenge,
those-
but
those
the
findings-
exercise undertook by the state government regarding reservation by way of office memorandum, that was under challenge.
But not the act, my lord. Only few portion of the OM, my lord.
That's all.
Only one thing, my lord, kindly consider in 92, the 78, the benefit which was given by the 78 Act was done with. Thereafter, even for the practice and this thing, my lord, in the state of Assam, we are the general public, we are suffering, my lord, because the state has failed to consider the fact that in 1992, 16(4) was held that it's not applicable to the reservation in promotion, my lord. But here, kindly, you do not have the right of reply, only I have. My lord, kindly consider.
I have a right
My-
of clarification.
Now, kindly consider how it is going on, my lord.
How it is going on?
My lord, wrongly, my lord, without following Supreme Court judgment, my lord. That's all, my lord.
You want to stop Mr. Das, but he is unstoppable. What to do?
My lord, he is
Only
very,
one thing I'll clarify.
Mr. Das,
Yes.
if you want to give some reply to him,
Yes,
give it
I'll-
outside only and nothing
Yes,
else. In the court, if any substantial thing
Yes,
is there.
I'll give my reply. One answer I could not make.
Yes,
Reply.
already over.
Yes, over.
Agreement, sir. Judgment reserved.
Next week.
only one thing, my lord, extent of reservation, what he submitted, my lord, that was dealt with in paragraph 119. That says of Nagraj judgment, my lord.
Consider.
Because, my lord,
We'll consider it.
my